Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
By gosh, make them work for it. You especially won't go to court if it's bullshit charges because you get them thrown out. By gosh, go down and fight them. From the Walmart.
All right. I'm here, but just barely. Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Why is the music so loud this morning? Oh my goodness. I don't know. It's really loud in my ears. And I slept in a long time. I see the snarky remarks about how late I am. Steve. I'm here now. Good morning. Oh my goodness. What a day. Happy morning. Come on in, have a seat, make yourself at home. I have to welcome especially Greeners today. Where's Greeners? Why is Greeners not on screen? Greeners, can you why is that not working? Where's 5? Show me 5. 5 is... I have no chat today. I have no... That means you get to see me get up and walk around and unplug. Every single thing in my room was broken this morning, except for my camera and my lights. Every single thing. I had to reset and reflash the memory on my switchers, both of them. I had to reprogram my recorder. Actually, the audio board was working fine. My laptop is just not connected. Everything shut off completely. My camera was completely powered off and would not come back on. And now I've got a plug I need to unplug and replug in. Hang on one second.
This is not Burger King. People do not get to have it their way.
So that's the extent of my skills. If this doesn't fix it... Oh, it did. Look, this live stream is the best. It's right there. Now I can welcome Greeners. I just used all my tech skills. Did I see the bare feet? Yes. It's one of those shows. I showed bare feet. He has legs, says Lizzie. I'm sort of proud of my legs. One day on a different social media, I'll show you those. No, we won't. We probably won't. Let's see. Greeners, first in chat today. Congratulations. I owe you the internet. Basically, that's what I owe you. But you've actually called it out here. It says days of internet ownership 3, days since getting timed up by Amber 0. Hopefully we can get one of those numbers a little bit higher today. Oh my goodness. Okay, check email for things to watch today, says Vicky. Thank you. And Vicky, it was fun visiting your stream yesterday. It was a lot of fun. That I had never watched that judge before. And now I have to put him on my favorites list. But I am curious if that is his official stream, his feed, or if that's somebody sharing his Zoom link. Internet ownership goes to Greeners. Greeners, take care of the internet. You fix it so we don't have a repeat of this morning. Oh my goodness, look at this. It's ARL Field Day. catch you, I hope, on the air. I will not be on the air today for 2 reasons. I think this is my only functioning ham radio, which you're probably not in range for me. My other ones is upstairs in the storage. And yeah. Let's see. Yes, I do have legs. I do have legs. Yes, he replied. Oh, cool. All right. I will check that out. I've got him favorited and watched. So, can we please talk about Buster suing for defamation? Oh my goodness, Buster. We're talking about the back to the Alex Murdaugh trial. Around that whole case, there was a lot of speculation and discussion about other suspicious things that happened. Oh, I've got a buffer sound. Hang on. That's because I forgot birthdays. Oh my goodness. Do you know why I forgot birthdays?
Mike. What day is it, Mike? Guess what today is?
It's Hump Day.
Hump Day! Hey, welcome to Wednesday. It's about like that. It's about like that.
I'd agree that everything you just said is one of the most horrible things I've ever heard.
It's Hump Day, and that's all I've got in me. That's all I've got in me, and now it's out of me. Ouch. 2 out of 10. My adoption child is gone for the week. But I have 2 fill-ins who gave me a 1 out of 10 as well. Oh my goodness. Yeah, it was weak. You got to do that. I've only redone Hump Day 1 time. Do you guys think you could do better? He's all, yeah. All right. That was a 1 hump yell. Let's see. My favorite Hump Day yell was during the fire alarm at the hotel. That's the only time I've done it twice because the live stream dropped, and I think you guys tricked me. No do. The diet is in full effect right now. Recovery Addict, do better. It was awful, but today has just been one of those things. We don't have court today. I want to hear the kids do it. Can the kids? Can you do a Hump Day yell? What are you eating? Pretzels. What? Pretzels. You're eating pretzels. You have to finish eating pretzels before you do the Hump Day yell because I don't want like pretzels all over the mic.
Yeah, eat pretzels. They're good for you.
I think my youngest one wants to do the Hump Day yell. Can you put these headphones on? I can try. Do you know how it goes? I can. Oh, you're. We're gonna get it. I'm gonna play the sound effect. Can you hear this?
Guess what today is?
You can hear that. Okay. So when he says it's Hump Day, then you have to do Hump Day and do a better yell. Not really loud and high, but okay. Here we go. You're gonna get little RA doing a Hump Day yell. Here we go.
Mike. What day is it, Mike? Guess what today is?
It's Hump Day.
Hump Day!
Welcome to Wednesday. There we go. 10 out of 10 for you, they said. 10 out of 10. Now 15 out of 10. 100 out of 100. Wow. Yeah. He nailed it. This is my kid. I think he has perfect pitch. The kid's amazing. He can, yeah. Anyway. Better than you, he says. Just clip that and use that, says Red Pen. He didn't like take a huge breath. That was a normal breath. He just sustained it. All right. Anyway, happy Hump Day. Welcome to Wednesday. We're halfway through the work week. So here we are. We're excited. We've got a few things to go over. I know Vicky just sent me an email. I need to check. I forgot the birthdays again. There we are. Okay, Sharon, thank you very much for reminding me. We will do the birthdays now before I get any further and forget them again, because that would happen. So, everybody, I know it's we're halfway through the work week. It's like the middle. There's just as much time since the weekend as there is before the next weekend. So I know it's a rough spot here, but I need you to do better than I did on the Hump Day Yell and stand up and sing with me as we celebrate the birthdays for Franco, Dunya, and Sean. Blend your voices with mine. Warm up with me. La 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 la. There we go. Here we go. Dancers at the ready. Happy birthday to you. Happy birthday to you. Happy birthday, Franco, Dunya, and Sean. Happy birthday to you. Franco, Dunya, and Sean celebrating their birthday. Happy birthday. I realize there are a million places you could be, a million people could be with, especially because it's a holiday today. I mean, the options just multiply. But you've chosen to be here with us. Thank you very much. Hopefully we can make your day a little special, or help yourself to free pancakes at Denny's, because any federal institution is closed and I'm not going to give you anything today. Good luck getting even a bank statement today. So, happy birthday to them. And also not the most important, but last but not least, I should say, Greeners and Mrs. Greeners celebrating their 13th wedding anniversary today. Greeners and Mrs. Greeners. Mrs. Greeners, first of all, I've got to ask you, how do you do it? How do you put up with... just to let you know just a little bit as we fade out the party music. You can keep dancing, but the party music's shutting down. I was woken up rudely, I would say. I was woken up rudely this morning, shortly after 8:45 a.m., when YouTube informed me that Greeners was already ready to be first in chat. And so I hurried and created the live stream. And as the stream loaded, like when you hit the button to say, okay, create the live stream, and here's your dashboard. Okay, like the dashboard I see right here, that once it's created, it's like, now it's ready. Greeners was over there, and he's like first, second, and third in chat. It's like, waiting. I don't know how you do it, Greeners. You got into chat before I created it. But congratulations. And Mrs. Greeners, he's got a talent. He's got a talent. Not sure if it's useful, but it's a talent. So, Greeners, thank you. It's wonderful to have you around. Appreciate you. And congratulations on your anniversary. That was awesome. It's all about adjusting the timestamps. There it is. Yeah, there it is. All right. Stream sniping at its finest. Yes, for those that understand that term. It's normally used with... Wow. Sorry, squirrel moment. I just got a memory on Facebook. 11 years ago today, I was walking on a glacier at Bloomington Lake in Idaho, filming people slide down the glacier on their butts. Actually, they were sitting on a Frisbee. And to film it, I had them wear a GoPro on their head and rode down into a glacier lake. It was freezing cold. I was distracted checking the email for sure. Yes, I'm sorry, Vicky. 1 minute. Okay, mailboxes, Recovery Addict. Oh, here we go. There's a few judges I haven't seen much of online. Don't think I've watched with you. I will subscribe to that one. Daniel Norbeck. Nice. I'll check that one out. Let me see what the other one is. William Mott, Chief Judge of 30 JD. Nice. Does a few lives and saves them. Okay, thank you. Vicky, you're doing some homework for me. I appreciate that. Jefferson County Court at Law Number 2. That's already looking good. Let's see. 34th District. Brian Oakley. I'm already subscribed to him. I watched him, but we haven't yet. There's a folder of streams I've saved right there. Good stuff. Thank you, Vicky. Appreciate that. Thank you. And love to be on your channel, by the way. Congratulations on the 500 subscribers. First of many benchmarks. But Karen Reed did an interview the other day. I saw that. Basically, she was asked, what do you think, 8 weeks into your trial, what do you think of, the prosecution's case against you? And she said, what case? They don't have one. I think it's a little stronger than that. I think at this point, the judge could not do a judgment of acquittal. Or, there's not going to be anything like that. It would go forward to the jury right now, even if, they stopped right now. But let's see. Vicky, I appreciate that was really generous of you. I appreciate that, and love it. Love your live stream, and love that you've got some radio background as well. It sounded great. Let's see. I was watching a restoration of Arrested F-250, and it was playing the verdict music. The verdict music is from the YouTube media library, which is, they have a list of music. Once you become a YouTube partner, once you be that threshold for them to care about you, actually, for them to know that you're big enough that you care about splitting the money they're already earning off you. I guess that's a better term. Once you do that, then they give you they throw you a bone, and they're like, hey, we'll give you some music and show you what you can use. It's predictive searching that we learned that Google Safari does on the iPhone. Yes. Where was it? There was something I wanted to get into before we start reading. Let's see, as soon as I missed it. It was there, and it was gone. Channels I work on in my day job are over 300,000 each, and they still don't care about us. Yeah, but at over 300,000, at over 100,000, you're supposed to get like the big thing. Yeah, I know you get a plaque, right? But the big thing you get at over 100,000 is you're supposed to have like an email for a real person at YouTube. It might be the bottom guy on the telephone pole, on the totem pole. It might be the very bottom low rung intern. But you get a contact with a real person. And until that point, good luck. The best you can do to ask for help from YouTube before you get to that point is reaching out to their support team on Twitter. That's all. Do we get a preview of the swishes? I've been working on the swishes, and I'm new to Fusion, right? Adobe. I don't use Adobe, sorry. DaVinci Resolve has a program sort of built in with it called Fusion, which allows you to manipulate stuff. And I'm new to it, but I've created a couple that work. My problem is I'm struggling to get the software is still in beta, and it's clunky. Info at YouTube is not a real person. No, there's supposed to be a real person that will actually talk to you occasionally. Like in person. I need to get to that point just so I can have a contact over at YouTube. All right, we have a little bit of reading to do. We're not just going to sit around and shoot the breeze. Let me see if I can pull it up. Bring it to the right computer. Let's use 3, shall we? It's not doing anything today. Okay, here we go. Send this one. That's a lot of pages. Beep, 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 beep. And then this one. It's a bad day to not have any water. All right. Asking if there's another Sarah Boone letter, says Andrea Hillis. Not that I know of. I'll do a quick check, though, because I have her on speed dial when it comes to that search. And we have no new letters yet. I might have to do a FOIA request and make the judge submit it. Is this the docs? Yes, that's what we're getting to. If I can get them pulled up on screen. Downloads. There's one. And here's the other. Okay. I think we've read some of these because some of these came out on the 7th. Well, I think these are all. They might include some old stuff, but we have new stuff as well. We are going back to the YSL trial, or the Young Thug trial, in Georgia. This one is crazy. I've said for a long time this will never go to the jury. This is going to end in a mistrial before it gets that far. But here we're gonna see why. And before we do that, DSN gifted a Get My membership this morning. Thank you, DSN, for doing that. Also, Maggie Carr, member for 16 months. Says, I'll be glad when the Karen Reed trial is over so I can get back to y'all. I've missed it. Yeah, we will be back with live trials once that trial is over. That's just a commitment I made for this one. Let's see. Who do we have? Missing. Brandy's not feeling well. Oh, man. Hope she gets feeling better. Honestly, she's been pushing so hard on this. For those that have in the past or currently do or have tried live streaming and running a live stream all day, there's a lot to it. Like mentally, there's a lot just going all day, even for just a couple hours. Brandy live streams all day, and then she produces one of the top true crime podcasts in the country at night. In addition to, she's been on interviews with big channels. In addition to the big TV ones as well. So she's burning the candle at both ends, and she's good at it. Is the reason. I mean, everyone wants to talk to her. See, how much longer is the judge going to allow Boone to keep changing lawyers and holding up her trial? Marcy, I think, here's the thing. The judge can't he can't force the lawyer to spill the actual details of the conflict if it breaches the attorney-client privilege. You can't do that, right? And so there's some terminology that her lawyer, Cashman, can make that the judge really can't penetrate into. He wants to see around. He says, show me, is there really something there? Let me know if this is really a problem or if you just want out. And so he'll try to probe at that and not let her leave. But at the end of the day, if it's like, it's unethical for me to do this, I can't do this, I think she'll get to leave. So I don't know how long it's going to keep going. Baldwin trial is coming up. I do want to watch that one. I think that's interesting. They've filed, the lawyers are working overtime in that trial on the defense. Part of me is wondering if Sarah Boone is trying to delay so long the evidence becomes old enough to try to and induce doubt. 15 years of delaying might give her a chance to avoid a life sentence. She's already, well, life is the worst as you can get at this one. She's only been charged with second degree, and that's all that's the maximum penalty. Baldwin trial is not allowing campouts. Meaning they're not allowing people to camp and get in. It's just first come, first serve. Okay, people will camp. They might not be on the courtroom property, but they will as close as they can be, and then you'll have like a mad dash. It's going to be terrible. Broken Baker. Are you in the house? I think I saw you briefly. There you go. Yes, I think, is that today? Or was that last? Did I miss it already, Broken Baker? You were going to have, I think, Runkle and Brandy and one other person I can't remember off the top of my head on let's see. Runkle had a video about it. They're creating a large perimeter. It'll create a stampede. It will. It's going to be dangerous, and people are going to get hurt. Is what's going to happen. And tempers will flare. Baldwin trial needs to do like first come, first serve, seating tickets for the next day. It's a simple solution. It really is. It involves a little bit more organization than courts typically have. But large courts that have dealt with huge media presences and massive public interest, they figure this out, and it's not terrible. Runkle and Brandy on the same stream was epic. We've seen them once together before. I think they were on STS, right? Together. Runkle wants to go in person daily. I think he should still go. I'd love to see Ian watching that trial. First of all, because of his firearms expertise and his legal background, I think he would be a great observer in that courtroom, and awesome. Let's see. Ian's take on the jury would be cool. All right, let's get to the reading, because that's what we promised you guys. That's what you're here for. We have, what are you guys looking at right now? Oh, me. Okay, let's go here instead. We have a document. This is a bit of reading. I'm going to try to tear through it, but not so fast that you can't understand what we're saying. And I'd also like to understand it as well, so I'll make it big enough for me to see. Get rid of my picture there. This was filed on the 17th. We've got a few pages. And this, for those that missed this story before, the Young Thug trial has been going on for about 30 years. No, not that long. I think it's approaching like 100 days of actual court time. But jury selection went for ages before that. They've got a jury. They've lost a couple people off the jury already, I think. I cannot read that one. Nope. Owens v. Eckerd is off limits for this channel. Anyway, so they've got this trial. It is a RICO trial, which is where those are special charges where they can use special laws to pursue people who are participating in organized crime. And they did this and said, all you 27 individuals, members of a gang, the YSL gang, are actually an organized crime unit. And all your little thuggery and your shootings and your drug dealing and everything else the gang is involved in. Is my mic a little low? It seems a little, my ears were a little loud today. I'll push the volume a little bit. All of those things that you were doing, that qualifies under these RICO charges. So we're going to charge all of you together. Well, they actually break them down into groups. And in this particular group, they have 6 members of the 27 who are being tried together. And what that means is, we've watched, another, believe it or not, it was another YSL trial where we had 2 defendants together. They were both charged with the same crime. They had different lawyers. Well, in this case, one had a lawyer and one did not. But they were charged in the same courtroom. So it's normally more efficient for the court to hold the trial together because the evidence against them is almost identical. And so they can do it all at once. One jury hears them both and then decides their fates individually. That's the idea. But with these 6 defendants, each one has 2 to 3 lawyers, and it's nuts. The objections, everyone wants to chime in, and my client's case is different, and so I look at this differently. Every time you do anything in court, and there's any room for an objection, you get 6 of them. Right, and the judge has to listen to all of them, and then the state replies individually, and then they reply back. It can't go. It's gridlock in there. Okay, now, anyway, we fast forward months of that trial, and we have a witness on the stand who is state's witness. Okay, he's got an immunity deal. They said, hey, if you squeal, if you talk, we won't charge you with this. And he initially said, okay. And then he took the stand, and they said, how old are you? And he said, I'm grown. He says, no, what's your age? I'm an adult. when was your birthday? I plead the fifth. That's what he did. And so pleading the fifth on the stand, that is terrible for a jury situation. Judge immediately, jury out. They lock this guy up. They said, look, you had a deal. Now we're going to hold you. And then over the weekend, they held him over the weekend. On Monday morning, they brought him and a fill-in lawyer for him into the judge's chambers with the state prosecutors and bailiffs and stuff, and put the thumb screws to him is how I see it. They twisted his arm. They said, you have to do this. You don't have a choice. If you don't do this, we're going to hold you in here until all 27 of these guys have been tried. It's not just the 2 years that we anticipate this trial taking. And he's like, I don't want to. He ends up firing his lawyer during that, and she quit. I'm not sure which happened first, but and he finally agrees, fine, I'll testify, but when I do, I'm going to lie. And the state says, okay, well, if you lie, we won't prosecute you. He's like, good, because I'm going to admit to committing the murder, which they know he didn't do. Okay, so now you've got a witness on the stand who's going to testify that he's actually the one who did the murder, which they've just said, well, we won't prosecute for anything you would. It's bizarre. So that's the backdrop for this. That event, that's out of the ex parte hearing in the judge's chambers with a witness who was under oath, testifying in court at the time, who was he was the last person on Friday, the first person on Monday. He's still on the stand. And in the meeting they had, in the middle, they had the meeting in the judge's room. It's bad. It's bad. It looks bad. The judge literally did something, had a meeting with a witness out of the presence of the defense attorneys that changed the way the witness would testify on the stand. And then wasn't going to tell the defense about it at all. Defense found out about it. And when they brought it up to the judge, he got angry, and instead of saying, oh, this is what happened, he said, you have to tell me, Mr. Steele, you have to tell, I think it's Mr. Steele, right? You have to tell me who told you about this meeting, because you shouldn't even know about it. And he's like, no, you have to tell me what happened in the meeting. And it was back and forth. And he ends up throwing Mr. Steele in jail, holds him in contempt, says, I'm going to sentence you to the maximum I can for contempt, criminal contempt, which is 20 days in jail. And it ended up that instead of holding him for 20 days straight, because that would deprive his client of counsel, then he says, instead, I'm going to hold you over the weekends, 10 weekends in a row. You have to serve Saturday, Sunday. It was just a mess. It was a mess. So with that backdrop, here are the motions. This is Jeffrey Williams, who says, this is a motion to disqualify and recuse the judge, who's Judge Glanville, from all further dealings in the above referenced case, and a motion for mistrial, which was goaded by the improper conduct committed in concert by the court and prosecution. This is the equivalent of lighting the house on fire. Okay, this is not routinely filed paperwork by attorneys in a court case. As soon as you start throwing around things like alleging a bias, not just a bias, but impropriety and illegality on the part of the judge and the prosecution, you start getting to a bridge too far situation where you can't get there from here anymore. You're burning the bridge behind you. You can't, and you're burning the bridge ahead. It's a mess. And so these accusations are very, very serious. They're so serious that the law is written in a very detailed way as to how they have to handle it when an accusation of this magnitude comes up in court. Okay, this isn't something the judge can just be like, denied. That's frivolous. No, there are things the judge has to do, and it spells it out. Okay, but here it's going to get juicy here. So let me read for you. Comes now Jeffrey Williams by and through undersigned counsel, and hereby files this motion to disqualify / recuse Judge Glanville from all further dealings in the above referenced case, and motion for mistrial, which was goaded by the improper conduct committed in concert by the court and prosecution. In support of this motion, Mr. Williams shows as follows. So stop right there before we go any further. The name of the filing This is hilarious. We've seen this before, because they did it in the Maya trial. Okay, Maya's attorneys filed a motion which had encased in its title verbiage that was not very flattering to the other side. And when you respond, you have to include that title in your response. So here, this motion, it's a very big motion. Instead of just motions to disqualify Judge Glanville. Okay, they could have abbreviated it, but instead they've got things in here like goaded by improper conduct committed in concert by the court and the prosecution. When there's a response, it's going to have this in there, and it just makes them say the things that you say they did, which is, I think this is hilarious. It's a fun little jab that the lawyers can do, and it's proper as far as things go here. So Jeffrey Williams is the defendant. He says he comes to the court. He's presenting this motion through his counsel, the undersigned, the people who are going to sign at the bottom, and he files this motion. And these are the things he's going to show. Undersigned counsel, so the lawyer who's writing this, represents Mr. Jeffrey Williams in the above styled reference case. The jury trial of multiple accused persons commenced January 4th, 2023, before Fulton County Superior Court Judge Glanville. It started January 4th of 2023. It's a long time ago. This trial is expected to last at least through the end of the 2024 calendar year. On Monday, I need to do that right here. There we go. It's a little bit bigger. Can you read that? On Monday, June 10th, within 5 days of filing this timely motion, this court, along with its prosecutors, engaged in an unlawful, improper ex parte meeting with, among other persons, a sworn witness, Kenneth Copeland, for and whom an order of use immunity had been issued on Friday, June 7th. So you had an improper meeting with a sworn witness who had a immunity deal that was issued June 7th. No notice of this ex parte meeting was provided to any attorney for any of the criminally accused in this case. So none of the defendants found out. In fact, the accused and their counsel were in the dark that this Star Chamber meeting occurred. Mr. Copeland had previously been called to testify on Friday, June 7th, asserted the Fifth Amendment privilege in open court in front of the jury, and was held in contempt and summarily, I want to add more RRs in there, feeling piratish today, summarily incarcerated until such time as he agreed to testify pursuant to the grant of use immunity. The reason, if we back up right here, him asserting the Fifth Amendment in open court in front of the jury, this is a problem, okay? For a jury to hear a witness plead the Fifth, it causes issues, okay? It's so much so that you are not allowed to put a witness on the stand if you know that they are going to plead the Fifth. Okay, you cannot do that. You are not. You can get serious, big trouble. That was me smacking my own hand. Ouch, for doing that. So he said, "Look, this just happened." He pled the Fifth in front of the jury. Okay, and then he was held in custody, incarcerated until he agreed to testify again after this meeting. Judge Glanville and the prosecutors essentially admitted by silence and by statements in open court that an ex parte meeting occurred on the morning of June 10th, only after the undersigned counsel revealed, based upon information and belief, that this impermissible meeting occurred. At the earliest opportunity, on the afternoon of June 10th, the court was informed, based upon information and belief. This is him, when he says based upon information and belief, this is the lawyer saying, this is information that I have been given. I did not personally witness this, but I have been given this information, and he's also not telling you where the information came from. Based upon information and belief that the ex parte meeting with sworn witness Kenneth Copeland and the prosecution occurred earlier that day, that the witness had made factual admissions, and that statements were made to the witness by the court and the prosecutor in acting in concert, so the judge and the prosecution were working on the same team, about the amount of time Mr. Copeland could be held in custody on the contempt. So you guys threatened him together, jointly. I'm going to highlight this. Thank you, Samantha. The court denied undersigned counsel's request for the transcript of the ex parte meeting. That means me, the lawyer who's writing this, I asked for a copy of that, and you denied it. And it denied the timely motion for mistrial based upon this improper and illegal ex parte meeting, which violated Mr. Williams' constitutional and statutory rights, including the right to due process, a fair trial, a fair tribunal, ethical prosecutors, and the right to be present at every critical stage of the proceedings under the Georgia Constitution. A transcript of the relevant proceedings on June 10th has been ordered from the court reporter. A video recording of the entire June 10th trial proceedings can be accessed online at there. Uniform Superior Court Rule 4.1 and Georgia Code of Judicial Conduct 2.9, so 2 places in the law, delineate rules governing ex parte communications. Ex parte communications are not, they happen, but they're exceptions. They're rare, and they have rules for when they happen. Under Uniform Superior Court Rule 4.1, generally it prohibits ex parte communications except as authorized by law or by rule. Judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceeding. Ex parte means ex parte hearings are only authorized in the case of extraordinary matters, such as temporary restraining orders and temporary injunctions. In other judicial hearings, both parties should be notified of the hearing with an opportunity of attending and voicing any objection that may be properly registered. Case law. Then if we go to the Judicial Conduct Rules 2.9, under the heading Assuring Fair Hearings and Averting Ex Parte Communications, okay, the goal is to not have an ex parte. Ex parte means you have a meeting without one of the parties. One party is X'd off, right? In this case, the defense was X'd off, and then you had a meeting with everybody else. Judges shall accord to every person who has a legal interest in a proceeding, or that person's lawyer, the right to be heard according to law. Judges shall not initiate, they shouldn't start it, permit, allow, or consider ex parte communications. Okay, judges should not. They shouldn't start it, allow it, or consider ex parte communications. Meaning, if somebody talked to them off the record, that shouldn't be something they weigh in their considerations. Or consider other communications made to them outside the presence of the parties or their lawyers concerning pending proceeding or an impending matter, subject to the following exceptions. Imagine if the judge every night got on Reddit and people gave them advice. And some people sent pictures of evidence that had not been submitted yet in trial. It was not allowed. This is the judge. And the judge, and somebody says, hey, by the way, just so you know, I've got some dirt on the defendant. I'm going to send that all over. Consider that. Okay, the judge is not allowed to do that. Everything the judge considers for his rulings in the case, and he's supposed to just be calling balls and strikes here, right? Is within the confines of the court. And this whole ex parte finding out on the side thing is frowned upon by the law and the rules. There are some exceptions, though. These exceptions are where circumstances require, ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with substantive matters and issues on the merits, provided that the judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communication. That means it won't help one side over the other. The judge makes provision promptly to notify all other parties of the substance of the ex parte communication and gives the parties an opportunity to respond. That did not happen. Second exception, judges may obtain the advice of a disinterested expert on the law applicable to a proceeding before court. This is phone a friend, okay? Judges they're allowed to phone one friend during a court case. Another might be a law expert. Brand new judge calls up, his favorite professor. He's like, look, professor, I know I got a C in your class, but that thing you told me to study that I didn't really well and you passed me anyway, I've got a case that has that. Can you help me out? What was the rule about? They can phone a friend a little bit, but they cannot allow that friend to make the decision. Judges may obtain the advice of a disinterested expert on the law applicable to a proceeding before the court if they give notice to the parties of the person consulted and the substance of the advice and afford the parties reasonable opportunity to respond. Judges may Consult with the court staff and court officials whose functions are to aid in carrying out adjudicative responsibilities or with other judges, provided that the judge makes reasonable efforts to avoid receiving factual information that is not part of the record and does not abrogate the responsibility personally to decide the matter. They can't push this off to a friend and say, help me out. You guys, I can't divide the baby here. What should I do? He can't do that. He can't ask another judge, do you have any advice for me? But he can't pass off the decision. In the end, it's on his shoulders. Judges may, with the consent of the parties, confer separately with parties or their lawyers in an effort to mediate or settle pending proceedings. Sometimes the two sides, the prosecution and defense, or the plaintiff and the other one, defendant, sorry, they're so far apart, like the hatred between them is so strong that they can't work together, even with the judge acting as mediator. And sometimes the judge has to just sit down and say, look, we've got to get through this. I need some answers from you. We've got to get through this. I need some answers from you. Now I'm going to, structure this. Now we're going to go to court. You guys just don't look at each other. Eyes on me. We're going to get through this. He can do little meetings that way. Judges may initiate, permit, or consider ex parte communications when authorized by law to do so, such as when issuing temporary protective orders, arrest warrants, or search warrants, or when serving on therapeutic, problem-solving, or accountability courts, like drug court, including drug courts, mental health courts, and veterans courts. And those are some fun courts to watch. I like those. Those are really cool. This court, going back to the lawyer speaking, this court violated 4.1 and JC 2.9. The court has joined the prosecutor's team and is biased against Mr. Williams and favorable to the prosecutors, as objectively demonstrated on June 10th, as well as throughout the pendency of the case. So it's like, yeah, we've seen it all along, Judge. You're biased. You are literally in the prosecutor's pocket, is what they're saying. The trial court rejected undersigned counsel's substantive request for information about the unlawful ex parte meeting, and the court denied undersigned counsel's motion for mistrial. Instead, the court stunningly demanded to know how the undersigned counsel came into possession of information about the ex parte meeting. The prosecutors stunningly sat mute and permitted this injustice to occur and for the court to attempt to intimidate undersigned counsel. Later, Love, a lawyer currently employed with the Fulton County District Attorney's Office, argued that the ex parte hearing with witness Copeland was ethical, just, and proper. The other prosecutor still remained mute. Undersigned counsel declined to join the antics in ignoring rules and ethical provisions and declined to provide information requested by the court, relying on State Bar Rule of Professional Conduct 1.6, which in pertinent part states that a lawyer shall maintain in confidence all information gained in the professional relationship with the client. So he says, I can't disclose that because the rules that I operate under as a lawyer say I can't disclose that confidential information. We're going to skip part of this one. The attorney-client privilege applies in all these situations. He's saying, I have the law on my side to not tell you what happened. The court ignored the ethical rules relied upon, or the ethical rules, I shouldn't say law, and continued to demand undersigned counsel to reveal the source of the information, claiming that the way the undersigned counsel obtained the information was somehow unlawful, and baselessly accused undersigned counsel on the record of potentially acquiring the information through eavesdropping. In response to the spacious accusations and the impermissible demands of the court, undersigned counsel relied on ethical mandates of Rule 1.6 and the Fifth Amendment right to remain silent, and declined to provide the source of information which had been proffered. The court is so biased against undersigned counsel and or Mr. Williams, the court ignored all laws and pursued contempt penalties to attempt to intimidate undersigned counsel, to violate the law and ethics in order to continue to help the prosecution convict Mr. Williams and all others. He's saying here, you guys hate me or my client so much, you're ignoring all the laws, and you're just trying to screw us over. The court issued a written order of contempt and incarceration for Brian Steele, imposing the maximum sentence of incarceration for 20 days. The Supreme Court of Georgia has granted a writ of certiorari. I can never say this word. Can someone spell it out with crayon in chat for me? Certiorari. There's a Oriari in there, and I have no idea how to fit it in. Can I just say rid of cert? Nope, I ate the crayon. Red, we need you. Writ of C, says Adam. Thank you. Thank you. I could have done that. Here we go. Matthew Harris. This one is one I trust. Certiorari. There's a sha in there? I can't even say that. Certiorari. Certiorari. A writ of certiorari. I will never remember this. It's Welsh. It's worse than Welsh. It's like sushi and Ferrari mixed together. Certiorari. Okay. I got it. Every time I say that word wrong, going forward, just remember that once I said it right. So the court was granted a writ of certiorari to address the appeal of the contempt order and has granted undersigned counsel to supersede this bond. Okay, the Supreme Court said we're going to basically put a stay on your jail time. You don't have to serve right now. This is going to be reviewed. Okay, this contempt order is going to be held. Certiorari. Soundbite it. So he doesn't have to say he's not going to spend weekends in jail right now. It's on hold. They might lift that hold and he gets to serve again, but thank you, Greeners. There's more words than that. You're being kind, only saying there too. The court violated the law, but this is why I can't be a lawyer. Right here, it's that one word. It's this word. This word comes up often, but this is the one that prevents me from being a lawyer. I failed the test. They're like, the last, it's a pass-fail question. Can you pronounce this word? And I'm like, I give up. That's it. So he was granted that bond, so he's not going to be in jail while this decision's pending. The court violated the law by failing its duty to recuse from presiding over this contempt proceeding. So it's illegal for them not to recuse themselves when he should have recused himself, is what he's saying. In such proceedings where the announcement of punishment is delayed and where, there's another one, contumacious, I'm going to say contumacious there. Conduct was directed toward the judge or where the judge reacted to the contumacious conduct in such a manner as to become involved in the controversy, which he did. The judge may give the attorney notice of specific charges, but the hearing, including the attorney's opportunity to be heard, must be conducted by another judge. I'm going to frame this. Can somebody screenshot that and frame that for me? It has to be done by another judge, and he sort of did it himself. Here's another case law example of what happened. The court should have recused and allowed the contempt proceedings. This is case law. Then going on to the next one. The court denied Mr. Williams, the undersigned counsel, their due process rights, as undersigned counsel has a right to adequate notice and to be heard, to call witnesses at a hearing, and to be represented by counsel for the entirety of the contempt proceeding. And Mr. Williams had the right to learn of the facts and circumstances of this critical stage of the proceeding that occurred in his absence, ex parte. So the lawyer is saying, you went through the proceedings against me without a lawyer, without my lawyer. I know I'm a lawyer, but I had the right to a lawyer when you said, as soon as you went from this is civil contempt to criminal contempt, I think that was where the line was drawn. Hey, Kurt, welcome. That's where he says, I should have had the right to a lawyer. I was deprived of a lawyer. And you took my client's lawyer away by holding me in contempt. Plus, I should have known what happened in the meeting to begin with. The court abused its authority by holding undersigned counsel in contempt for refusing to divulge privileged information and for protecting Mr. Williams' constitutional rights to due process, the right to a fair tribunal, right to a fair trial, right to be present, and effective assistance of counsel. This court's refusal to acknowledge, that was a new word, acknowledge. This court's refusal to acknowledge these rights and protections has created an unfair tribunal based upon bias against Mr. Williams and or his counsel, and favoritism to the prosecutors. These words, if used in other courts, this is gasoline on the fire. Okay, this is judges get big mad if you just throw these words around without justification. The motion to disqualify and recuse Judge Glanville is timely filed. It has to be timely. All your motions have to be timely. Some motions you have like a time limit to file. Other motions, basically in the moment you have to do it. Say, for instance, judgment of acquittal. There's a certain period during the trial where you ask for the judgment of acquittal. If you miss that period later and you come back, you're like, hey, I know we just finished sentencing, but is it too late to ask for a judgment of acquittal? Yes would be the right answer. Yes, it's too late for that. Let's see. USC 25.1 mandates that the time for filing a motion to recuse shall be not later than 5 days. So we had a 5-day period from after the affiant, that's the person who's making the statement or allegation, filing the motion, has learned of the grounds for disqualifications. Georgia, it's timely filed. So that's one of the things. Is it timely? Because a judge can throw out a motion just on being untimely. You could have the best reasoning and full support of the law behind you, and it's like, sorry, that was yesterday. Okay, it's the monopoly rule, right? When you land on somebody's hotel on Monopoly, you land on Park Place, and they forget to charge you rent. And then the next person goes, and they go around, and then you roll again on your turn, and you're moving off, and you go around to collect $200 from Passing Go. And then the guy who owns Park Place is like, wait, you were on my property. You owed me, it was $1,800 rent. Sorry. I did. You're right. You caught me. But guess what? It's too late. You can't do that. Monopoly rule takes effect. So we've got timeliness. That's one of the checks. The judge has to make sure a motion is timely, and he's saying this is timely under all the different reasons, all the timelines. This is timely, so you can't throw it out based on that. The record also reveals numerous instances during trial when the judge's behavior appears to have been biased against Mr. Williams' counsel and partial in favor to the state. Look, here's the other times that have happened where the judge just did things that just didn't look right, and he starts citing them here. Contentious. He says, see Millhouse, where they had a judge do derogatory and prejudicial statements in court. Yeah, that would be bad. The record reveals other instances, too, when the court wrongly berated counsel in front of the jury. After a number of such incidents, Mr. Williams' counsel, out of the jury's presence, moved for the trial judge's recusal and sought a mistrial on the grounds the judge had shown a lack of objectivity, had displayed bias against Mr. Williams and his counsel, and had assisted the prosecutors in making their case before the jury. The judge is supposed to be impartial, right? If I'm trying to think of an example, a sporting example that we can match this to. Imagine if you're playing basketball, and the ref on the court is he's got the whistle in mouth, watching for fouls and everything. And the other team's like coming towards you, and you've got their guys covered, and the ref's like, hey, I'm open, pass me the ball. And you pass him the ball, and then he shoots it to the other guy, and you're like, wait, it's like the ref took a pass and then passed the ball. And he's like, you're on the same, you can't do that. You have to be looking at this and just watch both teams and say, are you playing fair? Is this following the rules? You shouldn't be playing ball. And you definitely should not be shooting and scoring points for the other team, which he says you've done in front of the jury. You've been like, and not only that, you've been the cheerleader as well. You've been like, rah, state, you're the best. And I know that's probably not my best cheer ever, but it's now forever on YouTube. Anyway, so he's making these allegations. Save the cheerleader, save the world. Judicial code. In this regard, the trial judge shall avoid all impropriety and appearance of impropriety. This is important because a lot of times it might look from the outside, it might look bad. But if you just had a different angle, a different perspective on the proceedings, you're like, oh, it wasn't what it looked like. I just saw someone lifting a hammer and smashing it down. And from my perspective, it looked like you were hitting that guy's head. But when I turned from the side, you're actually squishing a spider that was crawling towards the guy's head. Oh, okay. That's a different situation. Hammers are appropriate for squishing spiders, by the way. So it has to not even look bad, even if it's not bad. We're supposed to avoid the appearance of impropriety. Judges should disqualify themselves in a proceeding in which their impartiality might reasonably be questioned. Did the video freeze? Sorry, I stopped scrolling. Am I on screen? Oh, I am. There we go. I was just on the wrong one. All right. Basically, if common sense looks at the situation and says, Judge, this one's a little too close to you, right? This is something you probably should back out of. That's what the code says. They should disqualify themselves. Look what happened in the Treehouse trial with Franklin Tucker. That judge disqualified himself. Well, first he was asked to be recused, but then he did disqualify himself, and probably rightfully so. The judge has a personal. Let's see. That this rule includes, but not limited to, instances where the judge has a personal bias or prejudice concerning a party or a party's lawyer. Within the context of this requirement, the word "should" means shall. Okay, it's like should is not just like good advice. It's like thou shalt. It's a commandment. It's a court commandment. The Supreme Court is mindful of the extraordinary pressures attending a criminal trial of this magnitude. On the one hand, defense counsel is obligated to vigorously defend his client against all the charges brought by the state, and likewise, prosecutors must effectively and ethically present the state's case to a jury. At the same time, the trial judge is charged with ensuring that the rules of evidence and procedure are followed, and the proceedings are both orderly, ethical, and fair. We all have our roles to play in this court, right? When these several interests come together in the courtroom during trial, disagreements between the bench and the bar are to be expected, and the instances discussed above in the attachment Exhibit B, joint affidavit, however, represent more than mere friction between zealous counsel and diligent jurist. So he's saying the examples up above, they're more than the normal friction that you get in court, where somebody's really wrapped up in their case, and you're like, I need to prove this point, and the judge rules against you, and you're like, Judge! And they're like, calm down. That's normal, right? We've seen that. We saw Mr. Anderson do that in front of Judge Carroll, just get riled up. And we definitely saw Hunter do it in front of Carroll, where the judge is like, you're on dangerous ground. Okay. Normally in court, you fight, and you fight vigorously for your side, and you try to win, and you don't always win. But he's saying these examples, this bias that showed up, it's more than that, Judge. It's more than just that regular, we have back and forth, and occasionally we're on different sides. The judge's conduct, and as discussed above and herein, created the impression that he harbored an inclination to be biased against Mr. Williams and his counsel, and partial towards the prosecution. The impression he's talking about is in the minds of the jury, because he says this happened in front of the jury, the berating me when you ripped me apart in front of the jury and gave me a dressing down in front of the jury, and praise for the prosecution. It makes the jury think the prosecution's good and the lawyer is bad, and that shouldn't be coming, especially from the court. That should not be coming in. All right. Judge has a personal bias or prejudice. The trial judge participated in ex parte communications with the prosecutor in the example in the case law. We're going to jump down to 17. Our highest court has set forth at least 3 circumstances in which recusal of a court is necessary. When they say recusal of a court, they're talking about the judge. That's the judge, getting off the case on the ground of mere appearance of bias. 3 ways the judge has to be kicked off the case, even just on the appearance. Even in the absence of evidence of actual bias, Mr. Williams does not waive that actual bias has been objectively shown throughout the trial. Okay, this is funny. He's saying there are 3 times where if it looks bad, it stinks bad enough that the judge has to be kicked off. And in showing you these examples, we're not saying that that's what happened. We still believe that it stunk for a reason, and that you're bad to begin with. But even just on the appearance side, there are 3 ways you also should have been off. And those 3 ways, let's see. First, mere appearance of bias requires a recusal of a judge when the judge becomes embroiled in the controversy with one of the litigants. If the judge is one of the two participants fighting uncontrollably in court, he's embroiled in the controversy. Let's see. Case law says relationship between the judge and the lawyer was such that due process required a recusal of the judge. The court favors the prosecution and is attempting to sabotage the defense. Georgia courts have followed this demand for recusal when the judge becomes embroiled in the controversy. Due process requires the trial judge cannot be both the prosecutor as well as the judge in our judicial system and thus must be recused. More case law where the judge reacted to supposed contumacious conduct in such a manner to become involved in the controversy. Now we're going to skip to the second one. The second reason, that just the appearance that he has to be excused for. Due process requires recusal of the judge when the judge takes a role in the accusatory process. More case law. It says here, Judge Glanville has ordered Mr. Copeland's lawyer and others to appear to give information on contempt proceedings, same as against the law. Importantly, the trial judge has the duty to recuse itself sua sponte, on his own, without us making a motion. The judge has the responsibility to recuse himself from any proceeding in which the judge's impartiality might be reasonably questioned, including instances where the judge has a personal bias or prejudice concerning the party. The phrase impartiality might reasonably be questioned means the existence of an objectively reasonable perception of lack of impartiality from the judge. Objectively reasonable, this means a common, a normal person's view, and not just like I had a bad angle type. A normal person seeing the situation laid out in front of them would say, yeah, that's probably not right. At that point, the judge has to recuse himself sua sponte, meaning with no motion needed. It's not one of those things where, hey, it was hearsay, but you didn't object, so we allowed it. No, the judge has that duty to, leave on his own. Let's see, where are we? To warrant recusal, the alleged bias must be of such nature and intensity to prevent the complaining party from obtaining a trial uninfluenced by the judge's prejudgment. To warrant disqualification of a trial judge, the affiant in support of a motion seeking the same must support the charge of a bent of mind that may prevent or impede the impartiality of the judge. The bent of mind, that's the preformed opinion in the mind of the judge that would prevent the impartiality. Recusal is objectively required when the judge serves both as the accuser and the adjudicator in a case. Let's see. In this case, the court met ex parte with prosecutors and sworn witness Copeland and never intended to reveal that ex parte meeting occurred to Mr. Williams or his counsel, or to anyone for that matter. The court has become part of the executive branch prosecuting Mr. Williams. Moreover, the prosecutors have abandoned and violated their ethical duties by engaging in this ex parte meeting and sitting silent while the court held undersigned counsel in contempt and failed to reveal any Brady evidence from the meeting. That's required discovery, including the fact that this meeting occurred. So this is important. Here's where he's bringing in the prosecutors to this, because as officers of the court, both lawyers for the defense and the prosecution, they have taken an oath, and as part of their oath, there are certain obligations that they are bound to, that they have to do, and one of them is they're not allowed to just say, put a witness on the stand and have them testify falsely, knowingly falsely. Okay, we're going to call a witness and he's going to say something that I know is wrong, but we're going to do it because it's going to help our case. Not allowed to happen. As a matter of fact, if they do call a witness and the witness testifies knowingly falsely, and the lawyer absolutely knows that the testimony that has just come out from their own witness is false, they have to correct it. Okay, it's not just enough. It's like, hey, I didn't tell him to do it. It's fine. We can roll with it. It helps us out. And so now you've got Mr. Steele here saying, in addition to the judge doing something wrong, the prosecutors, that was a weird enunciation, the prosecutors sat there, witnessed it all, and participated and didn't say a word. And that was wrong. And that puts them in the same boat as the judge now. The Brady evidence, when there's information that is required to be turned over to the defense, something that might be useful in their defense, new information that comes up, discovery is required to be handed over to the other side. And if new stuff comes up in court, it still has to be handed over in a reasonable time. It's like you can't just be like, well, we found out that there's actually a guy that the DNA matches to, and he was he did the crime, but we're not going to tell the defense because I think we can pin this guy as well for the same crime. You have to tell them if something comes up. Stuff came up in that ex parte meeting. There was stuff in there that was talked about that the defense has the right to know. The court and prosecutors should not be working together, but they are, teaming up to gain an unlawful advantage over Mr. Williams. Mr. Williams' trial is constitutionally fractured, unfair, and lacks all constitutional, statutory, and ethical safeguards and prosecutions of due process of law. The court is biased against the accused and his counsel. No intellectually honest person could believe coercing witness Copeland to testify in a star chamber setting. I've never heard the star chamber reference before. No intellectually honest person could believe that coercing witness Copeland to testify in a star chamber setting meets constitutional muster. Saying any outside person looking at the situation would know that you can't. Star chamber equals bad. Yes. The court has failed to follow the lawful path. Instead, the court has unlawfully become the prosecutor, judge, grand jury, biased, partial, potential sentencer, and thus must be removed from this case to in toto, instanter, now, without further ado, immediately, do not pass go. Go directly to jail is what you say. Now, this is a question for uncivil law, if I can, and maybe Matthew or somebody else, if you can chime in on this. The further this goes down this path of beyond the point of no return, which I think we've passed already, where the judge just continues ruling in his own favor and to the detriment of the defense, without regard to the law, as appears to be alleged in this motion. The further he goes, doesn't the remedy become? Aren't more options opened up as a remedy? What I'm getting at is there a possibility that if this goes way farther, that the court that looks at this and says eventually, because I think it will happen, that reviews this decision and says, yeah, you did wrong, could the defendants could this be dismissed with prejudice, is what I'm saying. Could this just be dismissed with prejudice as a result of how badly they were treated and illegally during the initial prosecution? Could these guys walk, even if they're guilty? And I don't know, like a bunch of gang members accused of doing gang crimes, there's a likelihood in my mind that there's evidence that they're guilty. And I haven't watched that. But is that a possibility? Or can they just be beaten senseless against their constitutional rights, and then the state gets another crack at it? All right. I'll watch for an answer here. I'm not sure if that's even a thing. The court has failed. Yes, that's possible in an extreme case. It gets so bad it irreconcilably violates due process. It's very unlikely, though. Because a normal mistrial would not be double jeopardy. Double jeopardy applies when there's a verdict, right? You can't be tried twice for the same thing. So if you're found, not guilty, you can't be tried for the same thing again. That would be the double jeopardy when that attaches. A general mistrial, though, that's just we're unable to get to the end of the process. We have to start over. The court has failed to follow the lawful path. Instead, the court has unlawfully become the prosecutor, the judge, grand jury, biased, partial, potential screener, and thus must be removed from the case instantly. On a motion to disqualify or accuse, it is the duty of the judge to pass only on the legal efficiency or the legal sufficiency of the facts alleged and to ask whether these facts support a charge of bias or prejudice. This is the rule. This is where the law comes in, right? As to what the judge can do. Because once you start making these accusations, the law is very strict on what has to happen. Okay, I think we've seen this before. Other states have a requirement. As soon as this motion is made, everything has to stop. You can't just keep going as if nothing's happened. This puts a wrench in the works. The wheels stop turning. It must be addressed immediately. The first things you have to look at is, hey, is this motion timely? Does it have the right parts? Is there, allegations in here that if true, would prove to be, problematic or show bias? There's very strict rules here. It is the duty of the judge to pass only on the legal sufficiency of the facts alleged and to ask whether these facts support a charge of bias or prejudice. Neither the truth of the allegations nor the good faith of the pleader may be questioned. It's not a fact-finding mission there. Regardless of the judge's personal knowledge to the controversy, the test is whether, assuming the truth of the facts alleged in the attached affidavit, a reasonable person would conclude bias exists on the part of the judge. The bar on this is so low. What's the sound clip? Oh, you sent me that sound clip, didn't you? I forgot which one it was. Was it via email, Amber? Sorry, I'm getting sidetracked, and there's a little bug in my room, a little fly. The bar is so low. This is not a fact finding where you're trying to decide who was actually right, if the accusation of bias is true or not. It's basically saying if a reasonable person looking at these facts would say, yeah, we have a problem, they've reached that threshold. Okay, the court's conduct raises a strong finding that has become personally embroiled in the case. It is clear, even to a casual observer, that this court's involvement in this controversy requires this court to be disqualified. Every time he says this court, it means the judge. This court to be disqualified, recused, and removed from all further proceedings in the above referenced case. Instanter. That means that's the same root as instantly. Mathis, thank you for this. All SCOTUS justices pronounce certiorari uniquely. That means that even the Supreme Court can't decide how to pronounce it. So I feel good also not knowing how. Thank you, Mathis. This court to be disqualified and recused requires this court to be disqualified or recused instantly, and another judge who will duly exercise the powers of the judicial branch with partiality, clarity, and fairness must be appointed to the case, saying we have to get rid of this judge and get a new one who will be fair. It's critical to the functioning of our courts that the public believe in the absolute integrity and impartiality of its judges, and judicial recusal serves as a linchpin for the underlying proposition that the court will be fair and impartial. Meaning, if the judge doesn't recuse himself, how can the public trust the system? The public needs to trust the system. The Georgia Code 2.1a mandates that a judge must disqualify himself in any proceeding in which the judge's impartiality must be reasonably questioned, or which the judge has a personal bias or prejudice concerning a party or a party's lawyer. This motion to disqualify Judge Glanville, accompanied by the attached affidavit, mandates that Judge Glanville shall immediately cease to act upon any matters involved in the state of Georgia v. Jeffrey Williams et al., shall immediately determine the timeliness of this motion and the legal sufficiency of the attached affidavit, that's required by law, and assuming that any and or all facts alleged in the affidavit to be true, whether recusal would be warranted. If it is found that this motion is timely, which it is, I like how he puts the answers in here, the affidavit is legally sufficient, which it is, and that the recusal would be authorized if some or all of the facts set forth in the affidavit are true, which it does, Judge Glanville must cease from any further contact with this case, and another judge shall be assigned to hear this motion and disqualify or recuse Judge Glanville. Judge Glanville cannot in any way oppose this motion. He is not allowed to rule on this. He has to just look at it and say, oh, we need another judge to look at this right now. That judge will decide if Judge Glanville gets recused. The attached joint affidavit clearly sets forth the facts and reasons for the belief that bias and or prejudice exist on the part of Judge Glanville. The allegations in the attached affidavit are not just bare conclusions and opinions, but are facts. Georgia Code of Judicial Conduct Rule 2.1 mandates that Judge Glanville must disqualify and recuse himself from this case. Instanter. Every time you see that, that means instantly. In the alternative, another judge must be assigned to this case and then order Judge Glanville recused based upon his conduct as stated herein in the attached affidavit. The facts cannot be ignored. To it, Judge Glanville's impartiality might reasonably be questioned by an objective observer, and thus Judge Glanville must be disqualified or recused from this case. A fair-minded and impartial person would hold a reasonable perception that Judge Glanville lacks impartiality based upon objective facts set forth in this motion and the attached affidavit, or reasonable inferences therefrom. A normal, casual person looking at this can say that he's biased. Furthermore, Judge Glanville's potential bias is of such nature and intensity to prevent Judge Glanville from being uninfluenced by his prejudgments. Judge Glanville's conduct gives fair support to a charge of a bent of mind, that's like a fixed idea in his mind, that may prevent or impede the impartiality of justice if Judge Glanville is not disqualified or recused from this case. He is so predetermined to rule a certain way in these hearings that he can't be fair. It's just not going to be able to do there. Let's see. This indictment must be dismissed. A mistrial granted based upon the court's and prosecution's continued misconduct, as shown in Exhibit B, attached here too. A constitutionally required fair trial occurred before a fair tribunal with ethical prosecutors has been violated. This includes, but is not limited to, witness intimidation. That's specifically to Copeland. Judge Glanville, lawyers for the state, Love and Hilton, will be called as witnesses at trial for the jury to understand this ex parte meeting and determine demeanor and credibility. Additionally, Mr. Williams demands all ex parte meetings be disclosed instanter in order to properly reveal the full extent of all violations of law and ethics. Again, lawyers for the state, Love and Hilton, and Judge Glanville are necessary witnesses at this trial hearing to determine the correctness of the motion for mistrial goaded by conduct of these parties and judge. He's basically putting them on notice. You will be witnesses in this hearing. Wherefore, based upon the above and the attached affidavit, if Judge Glanville does not immediately recuse from any and all further dealings on this case, this motion must be set down before another judge to determine why Judge Glanville can continue to serve as a judge in this case. Further, a mistrial must be granted based upon these judicial and prosecution violations of law and ethics. I think they're going to get both. They'll get a new judge and a mistrial. And it's signed by Brian Steele, who is the man of steel, the lawyer who ripped off his tie and suit coat and shoes and said, cuff me, take me to jail, but lock me up with my client so I can still work on his case. And then we have the exhibits. This is the order of contempt from the judge. I believe, during the proceedings in the above style case, one of the two representatives for defendant Jeffrey Williams, Mr. Brian Steele, took to the podium and stated to the court that he had been informed of an ex parte communication which took place in the court's chambers that morning, which took place. The only parties present for this ex parte matter were the court's official court reporter, representatives from the state's witness, Mr. Kenneth Copeland, and counsel for Mr. Copeland. In addition to the court's serious concern with how this information was improperly disclosed to defense counsel, Mr. Steele made several claims regarding the sum and substance of the communication that the court found troubling. The court having told Mr. Steele multiple times that he needs to tell the court how he came into that information, and the court having explicitly warned Mr. Steele that he faces contempt of court should he not comply, the court finds Mr. Steele has repeatedly refused to follow the court's order. Every court has the power to compel obedience to its orders and to control the conduct of persons connected with a judicial hearing. One who disobeys an order or command of the court may be found in criminal contempt. Before a person may be held in contempt of violating a court order, the order should inform him in definite terms as to the duties thereby imposed upon him, and the command must be express rather than implied. I think it was very express. The judge was quite expressive. let's see. There's the case law. Accordingly, it is hereby ordered that pursuant to court's authority under the law, the court holds Mr. Steele in direct criminal contempt for failure to comply with the court's order. It is further ordered that Mr. Steele shall be taken into custody of the Fulton County Sheriff and incarcerated at the Fulton County Jail for no more than 20 days for this contempt, with those 20 days consisting of every weekend for the next 10 weekends. Mr. Steele is to report to the Fulton County Jail at this address on Fridays and be released at 7 p.m. on Sundays. Mr. Steele's on Sunday, 7 p.m. Mr. Steele's incarceration is to start this Friday, June 14th at 7 p.m. and it is not to end until Sunday, August 18th at 7 p.m., subject to further order of the court, so ordered by the Honorable Judge Glanville. There's the exhibit. Then you have Exhibit B, a joint affidavit of Brian Steele and Keith Adams. So these are two lawyers. We are over the age of 18, suffer no legal disability. We make this joint affiant based on our own personal knowledge. We're counsel for Jeffrey Williams in the above styled case. This is the attorneys for Mr. Williams. And here's their statement, their affiant, or their statement that they learned of this, the events of the ex parte Star Chamber-like environment. Hey Siri, define Star Chamber.
Star Chamber means an English court of civil and criminal jurisdiction that developed in the late 15th century, trying especially those cases affecting the interests of the crown. It was noted for its arbitrary and oppressive judgments and was abolished in 1641.
Oh, nice. So they're using some good old history that has some deeper meaning in it. I was thinking it was just like our star witness in chambers, but no. This is when the crown is punishing people they don't like from 1641. This is why we rebelled against England and are in our own country now. They're accusing the judge of doing the same things the king was doing back in the day. That is choice. It just rings with poetic. It's beautiful. All right, so they've got the affidavit. This goes over what happened in what they believe happened in the hearing. So I'll try to read through this. It's really dense, but on Monday, June 10th, the affiants, specifically Brian Steele, asked to have a transcript of whatever conversations were memorialized, and the affiants requested the actual recording of anything discussed at this improper in-chambers meeting on said date. This court has obstructed Mr. Williams and below affiants from having an exact image of what was said. This obstruction alone shows that this court is biased and there is absolutely no privilege in communications in this court's chambers as this court argued on June 10th. There is certainly no attorney-client privilege under any stretch of the imagination, as this court asserted. The obstructionist conduct by this court shows bias and that this court is intrinsically intertwined in the facts of this case and has prevented Mr. Williams from due process, fair trial, effective counsel, assistance of counsel, right to know every material and critical happenings in this case. Further, this court, by its words, used on the record when speaking in open court with affiants as well as the court's silence as well as lawyer Love's statements in open court, clearly demonstrate that the facts below are true and accurate. The court has also silenced witnesses by improperly issuing a show of cause order for contempt and thus making all witnesses in fear of going to jail if the truth is told about this improper violation of Mr. Williams' constitutional right to be present at every critical stage of his trial, fair tribunal, and effective assistance of counsel. The silencing of witnesses, Mr. Copeland's lawyer, when she asked to withdraw from the case, the judge finally had to, because the law was just shoved in his face. He had to let her withdraw. Initially, he didn't want to let her. And then he scheduled a hearing that'll be held in 6 days for show cause. So you have to come and testify and show why this happened. He only wants to know if she was the leak, if she was the mole. That's what he's getting at. So yeah, he's putting people in fear of testifying. Let's see. Due process under the law. Well, we got that part. This court is biased and must be recused. Further, the cross-examination of Mr. Copeland will include facts that occurred at the Star Chamber meeting, which puts the credibility of lawyer Love, lawyer Hilton, this court in issue, and this court should never be the person who was in charge of the jury when the court's conduct is being questioned based upon the courts and lawyers of the state of Georgia's actions. Mr. Williams has been put into a trick box. by the misconduct of the lawyer. Hey Siri, define trick box.
Okay, I found this on the web for define trick box. Check it out.
A difficult situation, specifically circumstances that require a great deal of finesse to come out of unscathed. Physically, this term refers to inherent difficulty of solving Oriental puzzle boxes, but this instance of the phrase is used to reference to uncomfortable social situations. So, Mr. Copeland has been put in this trick box by the misconduct. This court must be recused, a mistrial declared, and barred by double jeopardy based upon prosecutorial misconduct and judicial misconduct. Those are not terms you throw around lightly in court. Mr. Kenneth Copeland, he's our witness, a witness who has been called by the state and sworn on Friday, June 7th, who invoked his Fifth Amendment and was held in civil contempt by this court, was brought to the Fulton County Courthouse on Monday morning, June 10th. Unbeknownst to the affiants, Mr. Williams, or anyone else on the defense side of this case, this court met in its chambers with Mr. Copeland, his lawyer, Lawyer Love, and or Lawyer Hilton, and at times, court reporter Weaver, as well as sheriff's deputies and other persons. Deputies may have been instructed to turn off their body cameras. This might be speculation. He's basically saying there's no body camera footage. But I don't think deputies in court typically run their cameras 24/7. There was and is nothing privileged under the law about this improper ex parte meeting. This court and the others met with Mr. Copeland for a lengthy period of time. The total ex parte meeting lasted for more than an hour, approximately 2 hours, with the above named people at the meeting at all or various times. Mr. Copeland continued to make known his assertion that he would not testify even in the face of being held in contempt and ordered to testify under use immunity. The contempt and order to testify, he had immunity, and he said he still wouldn't do it. The court and the lawyer for Fulton County District Attorney's Office and for Hilton ignored Mr. Copeland's decision and continued to declare to Mr. Copeland that he would be held in custody until he testifies, or alternatively, if he persists in refusing to testify, he would be held in custody until not only Mr. Williams' current trial resolves, but until all 26 indicted persons' cases are resolved, whichever is longer. He was threatened. This court was a participant and was present during these admonitions. I'm sorry, I've got a super chat. I just got to catch here just a second. I just need some space on the screen so you can read it. Let's see. This court was present. And during these threats to Mr. Copeland, this is witness intimidation, coercion, and the court has become a member of the prosecution team in assisting the prosecution to induce a material witness to testify. This court, lawyers Hilton and Love, are now all witnesses in this case and will be called by Mr. Williams or possibly other accused so the jury can determine demeanor and credibility of what occurred at this in-chamber meeting. Guess what you can't have? You can't call the judge to be a witness and still have the judge be the judge. Okay, that's why I think he's saying we're going to call you as witnesses. Please note that the witness list is hereby amended by this joint affidavit to include the court, lawyers Love and Hilton, and all other relevant material persons that have information to share with the jury regarding this conduct, words, and actions at this ex parte communication. He's like, it's official. We put you on our witness list. This court provided Mr. Copeland. This is good. With a written copy of the statute on crimes of perjury as well as false swearing. They printed it out and said, look, we can get you for these. There is no subtle gesture. This is no subtle gesture, and one that has helped the prosecution team to obtain their mission for Mr. Copeland to change his mind and testify. Lawyer Love made representations to this court in front of Mr. Copeland and his counsel. Hang on, I've got to put these up on screen here so we can see these. There we go. Hang on one second. KBF says many of our constitutional rights stem from the abuses of the Star Chamber. The right to remain silent, right to counsel, public trial, confrontation of witnesses, right to notice of the charges against you, etc. No secret trial. And then here's the judge being accused of having the Star Chamber himself. Thal says, all right, listen. All the judge has to do is use this subject matter jurisdiction, and poof, all the charges go away magically. Uncivil law, and Matt will back me up on this. I think, Thal, you're on thin ice on that part. Thank you very much. Appreciate you both, KBF and Thal. I love the super chats. The judge was going to argue, who was merely instructing the witness as to the potential that could happen, I guess, even though it seems like a threat. What the judge has already said happened, I think, violates the rules. They're in trouble. They're in big trouble. All right, so let's continue here. Let's see. Lawyer Love made representations to this court in front of Mr. Copeland and his counsel, sheriff's deputies, the court reporter, and others that Jonathan Melnick, Esquire, counsel for Mr. Copeland, committed misconduct during his representation of Mr. Copeland. Whoa, this is new. And was not representing the interests of Mr. Copeland. These are knowing misrepresentations by Lawyer Love to this court, which Lawyer Love continues to do. Jonathan Melnick was his lawyer who went out of town, and he had a lawyer, the lady in the light green shirt, fill in for him for just a day. And during that fill-in, they had this meeting, and she was there. And during that meeting, they said that Jonathan Melnick had committed misconduct in his representation. Your lawyer's he's not doing a good job, is basically what they're saying. These are knowing misrepresentations by Lawyer Love to this court, which Lawyer Love continues to do, which biases this court in favor of the state and against the accused, their lawyers, and other members of the bar. Further, the court permitting Lawyer Love to speak ill of Mr. Copeland's counsel in front of Mr. Copeland adds to the coercion and witness intimidation. It's getting deeper. This ex parte discussion violated Mr. Williams' constitutional right pursuant to Article 1, Section 1, Paragraph 12. Roman numerals are hard. Of the Georgia Constitution to be present. This is why I don't watch the Super Bowl, because I can never tell if I'm watching the current one or an old one, because Roman numerals. It might as well be metric for all I know. To be present at every material stage of his trial, this court and Lawyer Love and or Hilton speaking with Mr. Copeland, a sworn witness, about his testimony and whether he would change his mind and testify is clearly a critical stage of the proceedings. I would agree. As asserted in her motion to recuse this court, filed at 10:40 p.m. on June 14th, Attorney Bumpus, by her counsel, verified the below facts. These facts are adopted into affidavit below. These facts are assertions of Attorney Bumpus as statements of her lawyers. As follows. So here's Attorney Bumpus's statements on what happened here. Dahl says, as far as I can understand, it is not what was said at the meeting, it was who was at the meeting is enough for the appearance of impropriety. I believe you're right. Attorney Bumpus says this. She was the one that was released, right? She was the fill-in. Attorney Bumpus, there were Mr. Copeland and his lawyer, Attorney Bumpus, who is a fill-in lawyer, were escorted to the court's chambers and conducted an ex parte meeting regarding whether Mr. Copeland would testify. Those present for the substantive portion of this meeting were Judge Glanville, Mr. Copeland, Attorney Bumpus, lawyers Love and Hilton, members of the court's security staff, and deputies, 2 investigators from the Fulton County District Attorney's Office, and the court reporter. In chambers, this court asked Mr. Copeland whether he was prepared to testify. Mr. Copeland announced that he planned to again invoke his Fifth Amendment privilege on the stand. Guess what you can't do? You can't put a witness on the stand who says he's going to plead the Fifth. He says, that's what I'm going to do. A conversation among the parties ensued regarding Mr. Copeland's understanding of immunity, how Mr. Copeland thought he may testify if he did not invoke the Fifth, and certain facts of the case. Once Mr. Copeland learned that they were literally talking about the case. Once Mr. Copeland learned that he could be held indefinitely by the court if he refused to testify, not just the 2 years he initially believed, Mr. Copeland decided that he would testify. And Mr. Copeland added that his testimony would be a lie. The meeting ended and the parties went to the courtroom. This court never assured that this Brady evidence would be revealed to Mr. Williams or his counsel, and Brady evidence includes the fact that this meeting occurred. Instead, this court takes the position that no information about this meeting should have been revealed to Mr. Williams, his counsel, or anyone outside of the Star Chamber where same occurred. This shows that the court has become a member of the prosecution team in an effort to thwart Mr. Williams' constitutional right to a fair trial and a fair tribunal and due process, and a right to be present for each critical stage of the proceedings, right to call witnesses, right to present a defense, right to cross-examine witnesses on critical topics, including the facts of this case were discussed. With the court during the intimidation of the witness, This court must be recused. The court and the prosecution have violated Mr. Williams' rights, and the indictment must be dismissed after a mistrial is declared, as the court and the state has goaded Mr. Williams into moving for this mistrial recusal of the court. On Monday afternoon, June 10th at approximately 1 p.m., once affiants made the above known in open court, the court refused to release the transcript of this improper ex parte occurrence, held Mr. Williams' lawyer in contempt of court, ordered Mr. Williams' lawyer to serve the maximum period of time in custody for contempt, all in an attempt to intimidate Mr. Williams and his counsel from understanding and learning about the court's and the prosecution's wrongdoing. The court has become a material witness because undersigned counsel has the right for the jury to understand that this court met with Mr. Copeland and the prosecutors in order to convince Mr. Copeland to testify against Mr. Williams. The improper... Do you guys remember in the... let's see. When we got played in court. Why can I not remember the name of this? The prosecutor in the... It was Schroeder. The ZA trial. Thank you, Greeners. In the ZA trial, the prosecutor in that, there was a very brief meeting that he had with one witness. And that alone was enough to possibly put him as a witness in his own trial that he was prosecuting. Do you remember that? Think how much more we have passed that threshold in this case, in the Young Thug. The improper ex parte meeting on June 10th with a sworn witness concerning the witness's willingness or non-willingness to testify, and this court giving the witness a copy of the law of perjury and false statements and discussing facts of the case is unforgivable. This is not an ex parte meeting that the court has had with an affiant ever. The judge said this is just like when we have our ex parte meetings, and he's like, "No, judge, no, actually, we don't do that. We never have." On the very few occasions that the affiants have had an ex parte meeting hearing with the court, affiants announced in open court that it needed to speak with the court ex parte. There was no objection by the prosecution, and same occurred. Never was a witness involved in these rare ex parte meetings. Affiants demand to question this court and the above lawyers for the district attorney's office as to how many ex parte meetings they have had. There could be more. This might be the tip of the iceberg. The substance of those meetings, who was present, and the like. Even if just one ex parte meeting occurred, as did on June 10th, this mandates that the court has forfeited its role as an impartial judge and has become a member of the prosecution team. The court must recuse itself. The court, on at least one occasion, has been fed improper ex parte information about the facts of this case and the witness statement about his recusal to testify. The court met with a witness and spoke with the witness about the witness's willingness or non-willingness to testify, along with the prosecutors, and then held undersigned counsel in contempt when the undersigned counsel simply wanted to know why he was not notified of this ex parte judicially and ethically prohibited meeting. This court has now placed the lawyer for Mr. Copeland and other unknown persons in a position that they need to come before the court on a date certain to give testimony as to who gave information to affiants concerning this improper June 10th Star Chamber meeting with Mr. Copeland. I love that it keeps calling it Star Chamber meeting. The prosecutors and the court. The court has become the executive branch, conducting an investigation as a grand juror prosecutor. This court has lost all impartiality, and Mr. Williams cannot receive a fair trial with this court being present over the proceedings. This court has falsely and wrongly accused affiant, specifically Brian Steele, of being unprofessional and unprepared in the front of the jury. Neither claim was close to the truth or was accurate. The prosecutor sat silent as affiant was wrongly and falsely accused of improper conduct. This court has violated, that's the duty, okay? If the prosecutor knows that it's wrong and false, they have a duty to say something. The court has violated every neutrality, impartiality that was sworn to undertake. Even knowing that the court has falsely accused Brian Steele of being unprofessional and unprepared in front of the jury, the court has refused to instruct the jury to disregard the court's improper comments. This clearly shows that this court is biased and impartial against Mr. Williams and or his counsel and in favor of the state, as no fair judge would not correct such a serious misstatement made in front of the jury. The bias of the court is objectively proven. When Mr. Copeland took the witness stand Friday, June 7th, He refused to testify and was taken into custody by this court. This court knew, as did the prosecution, that Mr. Copeland would refuse to testify in front of the jury, but the court did not reveal that fact or take any action to stop Mr. Copeland's refusal to testify in front of the jury. Mr. Copeland's refusal to testify in front of the jury prejudiced Mr. Williams a great deal, and the jury should never have heard Mr. Copeland exercise his Fifth Amendment right. This court told the courtroom deputies to prohibit the media from filming Mr. Copeland if or when the court ordered him to be arrested. They shut the cameras off. This direction occurred before Mr. Copeland even took the witness stand on Friday, June 7th. The court has harmed Mr. Williams by hiding this information from Mr. Williams, having ex parte communications with the deputy and media, permitting Mr. Copeland to assert his Fifth Amendment right in front of the jury. When the Honorable David Botts, Esquire, brought to the court's attention that he had evidence that the prosecution knew that Mr. Copeland was going to invoke his Fifth Amendment right in front of the jury, this court refused to have a hearing to determine whether the prosecution knew that this witness would invoke his right to remain silent or refuse to testify. And instead, the court had a problem with Attorney Botts. This is backwards. This court has shown bias against Mr. Williams, his lawyers, and in favor of the prosecution. This court must be removed from further dealings on this case. This trial must be mistried based on goading and improper conduct by the court and the prosecution. Another trial is prohibited and barred by double jeopardy. Okay. I don't think he's right on the last part. But let's go back just a little bit. The part about the cameras getting thrown out. Why does it include that? This lawyer could care less if the cameras are turned on or off during the trial. Okay? But the part that is important here is he's saying the court talked to the cameras and said, don't film Mr. Copeland getting arrested when he pleads the Fifth. That proves, because they told them they did this prior to him pleading the Fifth, that proves that the court knew that he was going to plead the Fifth. If the court knew he was going to plead the Fifth, how did he know? Was there another ex parte meeting where he told him? Or did the prosecutors tell him? And if the prosecutors told him, or there was another ex parte meeting, we have more problems. The prosecution is not allowed to put that up on the stand. Why? If Mr. Copeland gets on the stand and is asked a question and he says, I plead the Fifth, guess what the jury gets to do? They get to make a negative inference about what he would have testified to. They get to assume the worst. Yes, that's prejudicial to the defense. Of course this would not be allowed. All right. In sum, the court must be recused and or the trial be declared mistried based upon the improper judicial and prosecutorial conduct that includes, but is not limited to, we're going to list all of them again. The court, lawyers Love and Hilton are now witnesses because they helped Mr. Copeland change his mind and testify by coercion. The court, ex parte, assisted the prosecution team by convincing Mr. Copeland to change his mind and testify against Mr. Williams. The court has obstructed justice by ordering any transcript of the June 10th ex parte meeting not to be produced to affiants to use to particularize this affidavit, as well as to cross-examine Mr. Copeland. The court, the lawyers for the state and or others before the jury. Facts of the case were discussed with the court at this impermissible ex parte meeting, and Brady evidence was not revealed to the affiants by the court or by the lawyers for the state. And Mr. Williams has questions for Mr. Copeland. This court, lawyers for the state and others about this improper ex parte meeting, how the same occurred, who discussed the fact that the secret meeting would occur, and the substance of this meeting so the jury can decide whether the court and the state have colluded against Mr. Williams. I swear the above is true and accurate. Signed, Brian Steele. And then he framed the pen. So, and then this just shows that it was delivered. And there's your emails if you need to ever deliver something to people. Official documents, of course. Now we've got this other one by I think this was Bumpus, isn't it? Let's see. Let me read through this. We've got a second document. We're almost done. This one is much shorter. Motion to quash order to show cause and motion to recuse this court. Comes now attorney Kayla Bumpus through undersigned counsel and files this motion to quash the court's order to show cause. Okay, this is the attorney in the light green shirt that we watched. that was the fill-in attorney for Mr. Copeland. She was ordered to show cause. She's supposed to be there on the 25th to show cause in court. She's now trying to quash that. She's basically, she's squishing it. Squash it. You put an S in front of it, and that makes sense. It gets rid of that order, so she would no longer have to comply. And a motion to recuse this court. So she tacks on the and judging to quit. Or in the alternative, moves this court to transfer this action to another judge or recuse itself as required by law. In support thereof, Attorney Bumpus shows the following. Recitation of the facts. On Friday, June 7th, during the trial, the state immunized Kenneth Copeland and called him a witness. Copeland refused to testify. The court placed Copeland in custody over the weekend for his refusal and adjourned until Monday. At this point, Copeland was still sworn as a witness and had not been dismissed. On Monday, June 10th, Copeland and his lawyer, Attorney Kayla Bumpus, were escorted into the court's chambers and conducted an ex parte meeting regarding whether Copeland would testify. Those present for the substantive portion of those ex parte meeting were Chief Judge Glanville, Copeland, Attorney Bumpus, Assistant District Attorneys Adrian Love and Simone Hilton, members of the court's security staff and deputies, 2 investigators from the district attorney's office, and a court reporter. In chambers, this court asked Copeland whether he was prepared to testify. Copeland announced that he planned to again invoke his Fifth Amendment privilege on the stand. A conversation among the parties ensued regarding Copeland's understanding of immunity, how Copeland thought he may testify if he did not invoke the Fifth. So they're saying, if we don't ask you that, or if you don't invoke the Fifth, what would you say? And certain facts of the case. Once Copeland learned that he could be held indefinitely by the court if he refused to testify, not just 2 years as he initially believed, Copeland decided that he would testify. Copeland added that his testimony would be a lie. The meeting ended and the parties went to the courtroom. Okay, so this is the recounting by the attorney who was present has less, it's not quite as flowery as what we initially thought. Initially, we were told that he said he would lie, and then the state said, well, if you lie, we're not going to prosecute you. And he said, well, then I'm going to get up, I'm going to testify that I killed him. And then he said, well, then we're going to try you for perjury. Those facts aren't here. Doesn't mean it didn't happen, but they're just not there. The ex parte meeting was not placed under seal. There was no protective order that directed that disclosure of these ex parte communications was prohibited. No attorney-client privilege existed. Clearly, as 2 prosecutors, investigators, a judge, a court reporter, and various court staff were also present. The court never stated, ruled, or inferred that the meeting was meant to be confidential. Further, the content of this meeting was not secret, protected, or in any way privileged information. It's unclear why any person present would have understood that the content of the meeting could not be shared with other attorneys of record in the case, who are also with fellow officers of the court. I think there's an extra "with" in there. She's saying there was nothing secret about it. She's practically admitting that she told them. Later that same day, defense counsel attorney Brian Steele addressed this court to make a record of his due process concerns regarding the ex parte meeting. The content of said meeting would not just be non-confidential, but would usually be given to the defense under the Giglio and Brady. So basically, it has to be turned over through discovery. During Attorney Steele's attempt to put his due process concerns on the record, this court began to focus on the identity of the source who leaked. Leaked to the meeting to the defense counsel. The court ordered Attorney Steele to provide the name of the person who divulged the existence of the content of the ex parte meeting. Attorney Steele refused. A brief hearing followed, and what initially appeared to be a classic civil contempt action — the attorney could purge himself of contempt if he provided the information to the judge — became a criminal contempt action. The court found Attorney Steele in direct criminal contempt. This court sentenced Attorney Steele to the maximum time allowed, which is 20 days, to serve in the Fulton County Jail. On June 11th, this court entered a show cause order directing all individuals that were present for the ex parte conversation that took place in the court's chambers on the morning of June 10th. It's a witch hunt. Specifically, Copeland, his attorney, Attorney Bumpus, all the representatives of the state, the court security personnel that were in attendance, to show cause why one or more of them should not be held in contempt for disclosing information from the ex parte conversation to members of the defense counsel. We are going to put the screws to each one of you. The judge will. Oh, my goodness. No specific names were included in the order other than Copeland and Attorney Bumpus. Mel and his law, welcome. Good to have you here. Argument. The court seeks to uphold in contempt the person that leaked the ex parte meeting to the defense counsel. Thus, the contempt hearing will be about who informed the defense counsel, whether to find the person is guilty of criminal contempt, and, if contempt is found, the appropriate punishment. The procedures that a trial court must follow to hold a person in contempt depends upon whether the alleged acts constitute the contempt to constitute the contempt were committed in court, which would be direct contempt, or out of court, which is indirect contempt. Now she's arguing the law here. This is going to get good. An alleged there's that word again. It's harder to read when it's in italics. Contumacious act may only be said to have occurred in the presence of the court, warranting summary contempt proceedings if the act was committed in open court. You can't have direct contempt unless it's in open court. On the other hand, where the alleged contumacious acts were committed outside the court's presence, the considerations justifying expedited procedures do not pertain. Thus, summary adjudication of indirect contempts is prohibited, and due process requires that a person who is tried for indirect criminal contempt is entitled to more normal adversary procedures. You know what that normal means? Lawyers. Among other things, he or she must be advised of charges, have a reasonable opportunity to respond to them, and be permitted assistance of counsel with the right to call witnesses. You've got to treat this like any other charge, Judge. You can't just say, meeting, back in my room, all of you, we're going to find out who leaked this. He can't do it because it was not direct contempt. Let's see, case law. The disclosing of information from the ex parte conversation to members of the defense counsel occurred not in open court or in chambers, but at the time and location the defense counsel were notified of the ex parte meeting. Further, direct contempt involves contemptuous conduct in the presence of the court, which generally results in immediate punishment. Here, the need for immediate punishment is clearly not immediate, as demonstrated by the show cause order being set 2 weeks out from the order. Forms of contempt are further divided into criminal and civil, based on the nature of the punishment imposed. Civil contempt is a conditional punishment intended to coerce the contemptor to comply with the court order. By contrast, criminal contempt imposes unconditional punishment for prior contempt to preserve the court's authority and punish disobedience of its orders. The contempt alleged by this court of disclosing information from the ex parte conversation to members of the defense counsel could only be criminal contempt. Nothing can be done to purge or undo the alleged contemptuous act, and any punishment would amount to criminal contempt. So she's saying we know that this would not be civil contempt, because civil contempt can be purged by simply complying. It's too late for that. It would just be punishment, which would make it criminal. No contemptuous conduct occurred. That's underlined and in bold. There neither is nor was anything preventing the disclosure of this ex parte meeting to defense counsel. Disclosure did not violate a court order. There is no standing order in place or trial order that bars or in any way limits defense counsel for witnesses or any other individuals present at the ex parte meeting from communicating with defense counsel for the defendants about the meeting and its contexts. There's no rule against it. And she's talking about ex parte, it cites ex parte rules. To the extent that the show cause order may be subject to a general demur, the order cannot pass this test, assuming as true the allegation of disclosing information from the ex parte conversation to members of the defense counsel. Contemptuous conduct is not alleged. Furthermore, contempt may be found only where attorney knows or reasonably should be aware, in view of all the circumstances, especially the heat of the controversy, that he is exceeding the outermost limits of this proper role and hindering rather than facilitating the search for truth. Lots of case law. Indictment must recite the language of the statute that sets out all the elements of the offense charged, allege the facts necessary to establish violation of a criminal statute. If either of these requisites is met, then the accused cannot admit the allegations of the indictment and yet be not guilty of the crime charge. Okay. Disclosure of the meeting did not exceed the limits of anyone's proper role. If anything, disclosure is facilitated the search for the truth. A judge may reasonably expect his clerks and other judges to keep what happens in chambers professionally private. However, they are under no legal duty to do so. Such an expectation of privacy does not extend to third parties and the third party is not part of the court staff. Holding an ex parte meeting in chambers did not impose a duty of secrecy. Informing counsel for defense of the existence of and content of this chambers meeting did not violate any rule of law, trial order, or standing order, and is not a basis for contempt. The show cause order, failing to articulate an act of contempt, should be quashed. This court must transfer this contempt matter to another judge under the procedure for indirect contempt or, alternatively, recuse itself pursuant to Georgia Code of Judicial Conduct. This court must transfer this matter to another judge under the procedure for indirect contempt. The court may not preside over this contempt proceeding because the court does not satisfy the following criteria. Indirect contempt actions, the trial judge who is presiding over the trial during which the alleged contumacious conduct occurred may preside over the contempt hearing if the contumacious conduct was not directed towards the judge and the judge did not react to the contumacious conduct in such a manner as to become involved in the controversy. Oh, another way that he's ruled out. This is crazy. Here, the alleged contemptuous conduct was, as expressed by the court, directed at least in part towards the court personally and the sacrosanct nature of its chambers. That's why the judge was so offended by it. The court became involved in the controversy both by holding the ex parte meeting in the first place and by way of the fact that this court is a witness to the potentially disputed fact of whether there was any kind of order to not disclose the meeting to counsel for the defense. The Georgia Code of Judicial Conduct court dictates recusal because the court's impartiality might reasonably be questioned. When considering the issue of recusal, both the law and Canon 3 of the Code of Judicial Conduct should be applied. The Code of Judicial Conduct provides a broader rule of disqualification than does the law. The broad rule of disqualification sets forth the Georgia Code of Judicial Conduct formally provides, judges shall disqualify themselves in any proceeding in which their impartiality might be reasonably questioned, or in which the judge has a personal bias or prejudice concerning a party or a party's lawyer, or personal knowledge of a disputed evidentiary facts concerning an impeding matter or a pending proceeding. Here, the court's impartiality might reasonably be questioned for 5 reasons. First, this court stated, "This is so sacrosanct to have a conversation in my chambers, parroted to you and others. It is that serious," revealing that this court views the harm to be, at least in part, a direct harm to this court personally and or the sanctity of his own chambers. Second, as described in the show cause order, some of the other participants in the ex parte hearing were the court's own security personnel. This gives rise to 2 issues. As potential witnesses, they may testify at the hearing, at which time the presiding judge will have to assess the credibility of their testimony. It might reasonably be questioned that this court would give more credibility to the court's own security personnel than it would to other potential witnesses, such as Attorney Bumpus. Further, the court's own security personnel and a reporter, like Attorney Bumpus, are subject to potentially being held in contempt. This court's impartiality might reasonably be questioned if it were to sit as both the prosecutor and the fact finder when deciding if it was the court's own security personnel and a reporter or someone else who disclosed the meeting. Third, this court has personal knowledge of a potentially disputed evidentiary fact of whether there was an order of any kind barring disclosure of the meeting for the defense, to counsel the defense. Further, this court appears to already have decided prior to any hearing that it was Attorney Bumpus who made the disclosure. While holding Attorney Steele in contempt, this court stated, well then, other than you, Attorney Steele, if you were sitting, unless you were sitting there with a recorder, or Miss Love or Miss Hilton, or one of the deputies gave you the information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left. And if that person gave you that information or shared that information with you, she probably violated privilege. This court's show cause order reinforces this predetermination, as the order references no other person present at the meeting by name other than Attorney Bumpus or Copeland. Fifth, and finally, The court was visibly impacted when it learned that Attorney Steele had been informed of the meeting. The Georgia Supreme Court referenced an opinion echoing this case in noting when a recusal motion clearly has merit, saying, but what if the motion to recuse has merit? What if the judge who announced an oral ruling, or reasonably appears to be, partial or prejudiced, and therefore has no business continuing to preside over the case? What if, for example, a party defending himself at a contempt hearing turns around and accuses the judge of prejudice, and the judge actively defends himself and then orally holds the accusing party in contempt? Explaining that the argument over recusal issues may draw the judge into presenting his side of the story, which in turn may create a perception that the judge is an advocate or a hostile witness rather than the impartial adjudicator in the case, requiring disqualification. So he was goaded into disqualifying himself. The alleged contempt is not ongoing and does not require immediate resolution. This court has ample time to transfer this case to another judge who is not involved in the ex parte meeting. She's talking about just the contempt case. She's not talking about the entire trial. Who is not involved in the ex parte meeting, who is not a potential witness to a potentially disputed evidentiary fact, who does not view the harm to be at least in part a direct harm to that judge's personally and or the sanctity of that judge's own chambers, and who is not called to determine whether that court's own security personnel or reporter committed the alleged contempt, and if so, what punishment to impose. This court must provide notice that fairly and fully informs the accused of the specific acts of contempt. You've got to charge. We need a charge document. When the full Penelope, ooh, I love this word. I'm going to say Penelope, but that's not right. Panoply. I'm going with Panoply. Final answer. First try. The full panoply of constitutional protections must be afforded to the accused. This includes a notice fairly and fully informing the accused of the specific acts of contempt. This requirement and reasonable notice in a case involving an alleged indirect contempt contemplates and necessitates a written notice fairly and fully informing the accused of specific acts of contempt with which she is charged, and so given as to afford a reasonable time to make her defense. Any notice short of that would make a hollow mockery of the fundamental and abiding truth that reasonable notice to one whose civil rights or personal liberty may be affected is a veritable cornerstone of our judicial system, would constitute nothing more than an exquisite exercise of frustrating futility, and sometimes misleading and always meaningless, and would be but sounding brass and a tinkling cymbal, a notice in form but not in substance. A tinkling cymbal. It has, oh my goodness. I love the references. Like all crimes, contempt has an act requirement and a mental component. So you've got the actus reus and the mens rea. Citations are omitted. The notice alleges an actus reus disclosing the ex parte meeting, but fails to put Attorney Bumpus on notice of the mens rea, or how the disclosure would know such an act amounted to contempt. Did she have knowledge that this was wrong? The notice does not allege facts from which a contemptuous mens rea could be inferred. As set forth above, the act disclosing the meeting to defense counsel cannot in and of itself amount to contempt. The disclosure could only potentially amount to contempt if it violated a court order or some other legal duty to not disclose the ex parte meeting. The notice fails to allege any such restriction. So if there was an order not to talk about it, it could have been contempt, but there's no order. As such, the notice fails to fairly and fully inform the accused of the specific acts of contempt. Wherefore, Attorney Bumpus moves this court to quash its order to show cause, or in the alternative, recuse itself from the proceeding and or transfer this proceeding to another judge whose impartiality can't reasonably be questioned, or in the alternative, provide an adequate notice that fully and fairly informs Attorney Bumpus of the alleged contempt. Should all of the above requested relief be denied, Attorney Bumpus requests a certificate of immediate review. Okay, the certificate of immediate review is asking the judge to put it in writing. And then he's not going to do that because he's in the wrong. And we've got all the attorneys signed on here. And it was delivered, signed, sealed, and delivered with a bow on top. here's the order to show cause that she's ordered to show up on the 25th of June. This is what the judge said. The court having been presented with an issue for contempt of determination, all individuals that were present for the ex parte conversation that took place in the court's chambers on the morning of June 10th, to include the witness, Mr. Kenneth Copeland, his attorney, Ms. Kayla Bumpus, all representatives of the state and court security personnel that were in attendance, are hereby ordered to show cause before the honorable judge on this date, at this address, why one or more of them should not be held in contempt for disclosing information from the ex parte conversation to members of the defense counsel. It's further ordered that the failure of any of the individuals who were present for the meeting will cause the failure of any of the individuals who were present for the ex parte conversation. Did he mess this up? The failure of any of the individuals who were present for the June 10th ex parte conversation to appear will cause, I think he needs it to appear in there, will cause the court to direct the Fulton County Sheriff's Office to take them into custody and bring them to bar in this court. He screwed up his own order. What's the failure? The failure of any of the individuals who are present will cause the court. I think he means failure. The failure is the failure to appear is implied, maybe. Affidavit in support of the motion to recuse. This is from, let's see, personally, affidavit in support of motion to recuse Chief Judge Earl Glanville. Personally, appeared before the undersigned officer, duly noted, authorized and administered oaths, Julian Collins, Kristen Nove, Gabe Banks, Nicole Mormon, Matthew K. Winchester, who upon being duly sworn, deposed the state in the following oath of perjury. Okay, these are her attorneys. They're citing all the same thing, and they're basically saying we sign on to this as well, with all their signatures. Because if we go back up to the people who signed, I've got to go farther. Right up here. There's Mormon. There's Banks. Winchester. Yeah, her attorneys sort of joined in that cause and just filed their own little also to stapled it to the back page. See if there's anything else. I think that is everything, and they got it notarized. So, yay! That's fun. Now I missed chat. What's happened over here? I think I missed a few comments. Let's see if we can go back here. Let's see. Maggie said, I'd be glad when Karen retrial's over so we can get back to y'all who have missed it. Alley Cat, member for 10 months. If this is how the judge acts on camera, imagine how he was before live trials. Thank you, Alley Cat. Congratulations on the 10 months as well. Bri Bear, member for 2 months, says, wow, 2 months already. The reason why, Bri Bear, the reason why the 2 months goes so fast is because you're on the jury, not just in the gallery. And the jury has padded seats, and so it's more comfortable, and time goes by quicker. You don't notice the uncomfortableness of the hard seats. Mathis helped me to understand that all the Supreme Court justices also mispronounced certain words. KBF, thank you very much for the super chat. No secret trial. Love the history about the Star Chamber. Thal came in with 2 super chats, subject matter jurisdiction, as well as the appearance of being improper. Thank you, all of you. Today, because it is a federal holiday, how many till 5,700? Let me look. I haven't looked here. Just 1 second. Where's my mouse? I think we're on 3, right? That's not it. There it is. It was at 9 and it went down to 3. So 6 people left. Was it my mispronunciation? That's it. I'm going to do a show cause hearing. I'm going to do a show cause hearing. Everybody who was here, come report. I need to see why you left. Jedi Jen, woohoo, 6 months today. Time flies when you're having fun. It sure does. Oh, 1 person came back. We're good. We're good. Who was that? You know who you were. All right. Melissa Smith, also a member for 6 months, says, Happy Juneteenth. It is. It's Juneteenth, federal holiday. First declared federal holiday in 2021. It is our newest federal holiday. Queen Olive, woohoo, 17 months. Queen Olive, thank you very much. I appreciate it. You're one of the OGs. Let's see, it's because you don't do warm-ups for reading long things. And I don't have any water. I need to go to the store and get some water. Red pen. You didn't miss any mispronunciations. So I got a text from Greeners, I think. Greeners just outed himself. He says, I was one of the unsubscribes and resubscribers, but now I can't chat for 5 minutes. So if you have anything to say to Greeners and don't want a response from him, now is the time to say it. Red pen. 17 months, all clean, present and accounted for. Red pen, thank you very much. I needed you earlier with some pronunciation, but it's funny. Greeners is our internet owner, but can't chat right now. Did Sarah's letter get in? We checked this morning. It had not come in. I'd love to read it today if it does, but I don't anticipate the court is updating records today with it being a holiday. Let's do a quick check for Sarah Boone. I'm not a robot. Boom, there we go. We're waiting. No, letter's not there. We do have a record in the court that the court was provided with a letter in open court, and they're required to post it. They can't just leave it sitting there. So it's just a matter of time. It might just be that the judge is reading it first, and once he's done with the 58 pages, then he'll have it scanned in. Witchy Mama, see something, say something, says, thank you, RA mods, and all you fabulous folks who make this community awesome every day. Thank you, Witchy Mama. 9 months as well. It wouldn't be the same without you. Thank you very much. Kiki's Garden says, this community is amazing. Thank you, RA, for helping me reach 50 subscribers on my channel. Kiki's Garden, we need to get more than 50. We need more than 50 over there. But love it. It is so much fun. Just having a creative outlet is just amazing. Don't stop. Don't stop. I didn't mean don't stop. I said don't stop. Okay, something freaky just happened. My light just got brighter over here, which it shouldn't do. Do you guys do that? Greener says, I put shaving cream in your toothpaste. Greener's timed himself out. Let's see. We thought Judge Fink was out of hand. Speaking of Fink, no ruling on the Kelly case yet. The Kelly case we're talking about, that's the border rancher trial, George Kelly. We are waiting for Judge Fink to issue a written ruling as to the dismissal of the case, whether that's going to be dismissed with prejudice or not. If it's not dismissed with prejudice, it leaves the door open for further prosecution. And we're hoping in this case, especially with their age and everything, that doesn't happen. Ivy Berlin says, I'm so addicted to this channel, I prefer to hang out with you instead of watching Germany versus Hungary soccer tonight. That should be a good game, though. Germany's always a good team to watch. Let's see, Karen Dietrich, member for 13 months, says, so happy to be here with all you wonderful people. Best place on YouTube, Karen. You guys make it the best place on YouTube, and it's how you treat each other, even when we disagree, which we tend to do once in a while. It's amazing. I love it here for that reason. Greeners says, so I can still super chat, but I can't free chat. Hump. Yes. Can I buy a vowel? I guess super chat's the only option for you. You've got just a couple minutes, and you'll be back in chat, or maybe any second now. Your 5 minutes should be over. When Amber times me out, I can't super chat. When I time myself out, I still can. Let's see. Johnny Thunders. Did we ever find out about the probate case? People fighting over the will. Johnny, I wish we did. I've never seen that response. That judge doesn't publish his cases and link things together. A lot of things get deleted or just not shown. So it might have just slid under the under the radar one day. And it's also very likely that in that particular trial, because it was a civil matter over, inheritance, once they got the results of the DNA test, the parties just agreed. It's like, well, look, she's one of us, or look, she's not one of us, and just moved ahead that way. And didn't require a big presentation in court to do so. Bug Dugger takes this moment to laugh at Greeners appropriately. So Greeners says, I can breathe again. I was about to become poor. Greeners, thank you. Appreciate your support. Greeners, you're going to have to, if you could be first in chat with a super chat. Nobody has done that before. I'm just saying, nobody has been first in chat with a super chat. That would be like, that would be I think that would, it might even be a world record, like a Guinness Book of World Record. I don't think any channel has, with a substantial following has had a first chat be super chat. AZ DCS Oversight gifted a membership as well. Went to Johnny Thunders. Johnny, look, you asked a question and immediately you get gifted with a membership. Thank you very much. Appreciate that, AZ DCS. Steel and Stitches, welcome to the jury. Look at that, padded seats. Padded seats. Greener says, unsubscribing from Recovery Addict is no joke. It cost me $10. Greener says, I'm laughing with you, not at you, just so you know. Appreciate you learning the lesson the hard way. Kim R says, Greeners, I always subscribe and unsubscribe so I can subscribe again to RA and always be at the top. That's what's happening. Let's see. Good morning. Happy Juneteenth. Throw out the bait. No, don't challenge him. You guys, by me challenging Greeners to do a super chat as the first message, it takes time to super chat. Okay? It actually gives other people an opportunity to beat him into chat. I'm just saying, it's yes, it helps me, but it also helps you. I just found the emotes. They apparently have a middle finger. Let's see. Quitters never prosper. That's the moral of the story. Let's see. Any news on the Robert Tellis trial out of Las Vegas? It was delayed last I heard. Let me take a quick peek at our trial calendar, which I need to update. Let's see. Upcoming cases. Robert Tellis. That was like 8/5 is what I've got. Is the latest. I've got a date of August 5th. I'm not sure if that's the next hearing, like a pretrial hearing, or if that's a trial date for Robert. Good question, though. That will be one that we might watch while I'm at an Airbnb. See what's coming up. Where are we at? January, February, March, April, May, June. Is that 6? I'm counting on my fingers. Mower updates. Yes, I'll give you an update. I ordered the wrong carburetor. I ordered, I don't know what it's called, a double barrel carburetor, and I need a single barrel carburetor. So I ordered another carburetor that says it doesn't fit my carburetor, which I don't know why I did it, but the first one said it fit and it doesn't. So now I order one that doesn't fit, and I'm assuming it does. But it fits the model just smaller than mine. So maybe they use the same part. I've got my fingers crossed. Oh, Robert's in federal court? He's in federal court? Yeah, we'll get news reports. That's it. Like newspaper reports. Greeners. 1, 2, 3, 4. No, 1, 2, 1, 1, 2, 1, 5. Okay, I see. They added the bird. There we go. Your birthday is next month. Hazelnut. Excited. We'll sing to you then. What happened to the Treehouse trial? I believe we have a hearing coming up within the next week or so, I believe. We'll be catching up on Karen Reed today. Not today. We'll be catching up tomorrow. We're going to stay one day behind on that trial, and it's just that trial. That's it. Do you think you'll cover the Kansas trial where like 5 people were arrested? Is that where the 2 moms went missing, and then they found their bodies and they arrested 5 people? That's going to be, I mean, if that goes to trial, I'm going to say that's probably a couple of years out. And when you have 5 people, you've got a lot of opportunity for one person to turn on the others and testify against them. And when that happens, it's like an open and shut case. So we'll see. There's a full trial, Dale something on that folder they haven't decided on. You're welcome if you're short. I'm good. It's a holiday today, so I'm not going to make you guys work all day long. We're almost to lunchtime already. The bird has been on there for a while. I've got a necklace with it on. At Strata23, thanks for clicking the subscribe button. Your subscriber number 56,925. Just so you know, I happen to be able to see it go up right as you clicked it, so I can tell you that. And that's the only time you'll know. So write that number down if it's so you can say I was here when. Okay. What will I listen to this afternoon? Says Paul Mac. Let's see. The Creative Bee. We just mentioned that. I think you missed it. We're waiting for Judge Fink to issue a ruling on that to see if he'll dismiss the case with prejudice. We're not sure. It should come out probably in the next week or two, I think at the most. Little B, a member of the jury as well, says thank you, RA, and all mods. Thank you, Little B. Thanks for your support, and congratulations on 8 months. Next month we have a big reveal, right? Nothing yet on that case. What number subscriber was I? I can only tell you if it's... Well, I can tell you this. If you unsubscribe and subscribe right now, you would then become 56,925, but you would lose your position. So you might have been 1 before that, but you'd lose your position. Let's see. Matthew says, I'm trying to finalize my live setup. Might set up a test this afternoon. That would be awesome. I would... If you make a thumbnail for it before we go off here, I'd love to point to it. And are you going to be doing StreamYard or OBS, or did you go like me and spend the big money for the the overkill with the hardware? Yes, we're going to have Matthew Harris on. If not for a trial, at least for a podcast or two. OBS because I'm poor. OBS is great. It just takes more work than I'm happier configuring hardware and using that. Like I love this little thing right here. It just makes me happy. Anything I want to do, I can do here. Let's see. Let's look at SuperSource. Let me see what SuperSource is doing. Say I want to do like a 4-box. Like this. Yeah, and I can switch using this as well. So let's go to SuperSource. Say I want to do this. I'm a 4-box in a box. That happens to show my hard drive storage space for my NAS. Not sure why it wrote in stripes like that. That's weird. But anything I want to do on the live stream, I can do using these buttons. I can move things around every which way and just, I think I can even do like up to 6 windows and stagger and overlay. You know, how do you want to watch court, really? I mean, this is I can do just about anything, and it's all from this. And this is just the SuperSource. That's just the layout of how the screens look. Within that, I can also do all my overlays, my auxiliaries, my multi-view setup, all my audio settings, media. It just makes everything work. Can I make popcorn? I think there's a button for that. It's got 78 pages of buttons. What are the odds he accidentally presses the end stream? To do that, I would have to go to output. Oh, it's actually pretty. It's just a 2-button. It's just a 2-button. So you look from the main screen, output, and stop stream. Then it's over. That would be the end. I'll go off that page just in case. Rejected Juror just gifted 5 memberships. Those went to, in my opinion, Red Ford, Aaron Beasley, You Can't See Me, and Stuff. And Stuff. I love that. Alt F4. Mrs. Constitutional Rights, welcome. Did I see you click the subscribe button? You are number 56,926. Congratulations. Miss Constitutional Rights. Stream decks are amazing. The downside, the flip side of them is they can be a pain to program. It's not something you could just buy, plug in, and it works. In my case, I bought some software that works on my computer over here. It's actually that software on the screen, and it comes with, you pay $50 for that, and it comes with the software that loads this on, and then they talk to each other and work together. Rejected Juror said, I've been preparing for job interviews. I got the job. I wanted to share gifted memberships as soon as I have received several when I couldn't afford them. Rejected Juror, congratulations. That is awesome news. We all knew you were going to get the job anyway. So we were not surprised, but we're happy for you either way. That deserves a little bit of a party. Congratulations. Rejected Juror needs to change name to New Hire, says Greeners. Anyway, what are your plans for the rest of today? I know it's a federal holiday, but a lot of people still have to work today. So if you're working, let me know by putting a thumbs down emoji in chat, and then we'll say sorry. That's all. We're done with the reading today. No courts are really in session. I think if there are courts, they might be just arraignments. Let's see. Let's do a quick scan of who's up. Let's see.
Somebody just sent me a video of roaches fighting.
I don't know
who won.
Ooh, there's a court out of Sebring Bank shooter sentencing trial out of Florida, but it's a single news camera that's filming it, so they would get hit with a strike. OG Sean White says, I'm working. Thumbs down. Oh, my goodness. There are thumbs down all over the place. Kimar, did you see my announcement the other day? I got a promotion. No, I also missed Lenovo sent a super chat like 2 days ago. And it was right after I had ended the stream. And I went out and was talking to my wife. Later that night, I came in to shut down my computer, and it was on the screen. I had just barely missed it. I'm sorry about that, Lenovo. I'm sorry, OG Sean White. So many people working. Retired, playing with grandkids today. EDB is about to go live. I don't think she lets people link to her. Let me see if Matthew has a thumbnail up yet. Let's see who's on redirect for us. I see Megan Fox, Legal Mindset, LTL Media, Weather Watch. Weather Watch, I see a test coming up. Matthew says, I gave all my staff the day off as a paid holiday. Good. Good on you. That is a good move.
The zombie apocalypse may
I
be
see
upon
Broken
us.
Baker for tomorrow. Surviving the Survivor. A couple metal detecting channels. Matthew, I don't see a thumbnail for you, or maybe it's just not letting me see it, but I can't link to. I don't think Vicky's found the setting yet that allows me to link to her. Double working, it's not a bad thing.
Are we going to address subject matter jurisdiction?
I think we've covered everything. I think we have. Got stuff to watch on stream, but I don't know how to allow a redirect. The redirects, let me see if I can tell you really quickly. It's in the, I believe it's in the studio under channel settings. Let's see. Nope, that's not it. It's in the main studio, like not inside the live stream, but in your main YouTube studio page. If I can get there. Go back up just a tiny bit. Okay, under settings, channel. Let's see. Well, that's where you allow viewers to clip your content. That's good. I thought I had it, but I can't. Basic info, no. Advanced settings. You know, Vicky, I can't find it either. So maybe it needs to be Googled. Vicky, found it? Okay. Do you have one? Are you going live? Because I'll redirect your direction if you are. Vicky has some court cases that she follows. Some fun judges. We might start watching a couple of them as well, but let's see. Okay, I found it. It says not sure yet. I was able to link to it. Let's see if Matthew Harris is there. Vicky, I did promise Matthew first, so if he's got one, I've got to go to him first. We can go to yours a different day if you're going to go live. Ooh, I have Matthew Harris test stream. Okay, we're going to redirect to Matthew Harris. Can you choose your own adventure portal? You can. Matthew Harris Law PLC is what we're linked to. If you go to Google and you search Vicky McCallum, that is her channel name on YouTube as well, so you can choose either way. But what this means, sadly, even though it's hump day, we're only halfway through the work week, is I'm going to give you guys the rest of the day off. And you get to go home. I get to have breakfast. I haven't had breakfast yet. Tomorrow we're going to be back with the Karen Reed trial. We're going to be following the testimony from 3 professional or expert witnesses for the defense. And it's weird because it's in the middle of the state's case. This is a proffer for the judge to see if she's going to allow them in court. The judge has not made the decision yet. We'll see what happens. It'll be interesting because they were hired by, well, let's see, they are the FBI. They're hired by the government. So, Department of Justice. All right. Everybody have a wonderful Juneteenth. Have a wonderful holiday if you have to work. Thank you for working. Somebody has to do the heavy work so the rest of us can play. You guys have taken one for the team today, so appreciate that. Tonight when you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. And please stay safe till we go live again tomorrow morning at 8:30, 8:45-ish. Meanwhile, we're going to portal over to Matthew Harris's channel where he's going to show off his amazing new studio and a few of his dance moves, which I wasn't supposed to. Was that supposed to be a secret, Matthew? Yeah. Don't let him stop the live before he shows off the dance moves because he's got them. So, you guys, it's been great. You can use any of my music for your dance moves, Matthew Harris. Just whatever just feels right. It's been great. Till tomorrow, have a great day. I appreciate all of you. Thanks to our amazing mods. Thanks for making this the best place to watch true crime. Be good to each other. We'll see you over at Matthew Harris's channel or at Vicky's Have a good one. Bye-bye.
Because he's the guy.
Incoming portal.